Just a heads up, everybody. I think I have successfully started the live stream. We start that early so that everybody who wants to watch you can watch you, and so that they don't get upset when they don't see that on early. Our plan is to start promptly at 10. I don't know of any reason that we can't do that. I'll ask folks to switch their names to either their witness name or, right, if you're the side of the case, your side and or your Mountain Peak name, so that we can make sure we have all of that straight. We'll start promptly at 10, assuming that everybody's here by then. just so I can ensure that we have all of the judges here that we're supposed to, because I know that sometimes people come onto the computer in a different name. If you're a scoring judge here in this round, would you use the raise hand function so that I know that you're here? And if you don't know how to do that, if you can just turn your video on briefly, I promise we won't judge. But I just want to make sure that we have all the scoring judges that are supposed to be here. Okay, thank you, D. Smathers. You can put your hand down. Any other scoring judges here? So folks, give me just 1 second. I realize I said that we're going to start at 10, but I'm going to check in real quick with the competition directors about that. So bear with me for just a moment. So folks, we may need to delay just a couple minutes to make sure that we have all of the scoring judges here. I want to make sure that everybody's here who should be here. So bear with us, and I'm sorry to ask you to sit for a minute because I know everybody wants to get going. Again, so, and I know somebody just came into the room. If you are a scoring judge, would you use the raise hand function and let me know that you're here? Or like unmute yourself and tell me that you're here.
Your Honor, I also sent you a private message through the chat function.
Mm-hmm. Oh, wow. Okay, I see that. Thank you for letting me know, Counsel. Again, for anyone who's watching on YouTube and wondering why we're not starting, we're delaying the start. We're waiting on a couple of scoring judges here. We want to make sure that everybody's here who needs to be here at the start of the trial. So bear with us for just a few more moments while we make sure we have everybody here who should be here. We thank you for your patience, and thank you to the advocates as well. And again, if there's anybody in the room who is a scoring judge other than Dane Smathers, would you please unmute and let us know you're here, or raise your hand so that we know that you're here? Again, for anyone who's watching the live stream, Courtroom 2, sorry, hasn't started yet because we're waiting on a couple of scoring judges. We've contacted the tournament director. They've asked us to, or I guess we've contacted the appellate court. The appellate court has asked us to hold off a couple minutes to make sure we have everybody that we need. As soon as we have everybody that we need, we will begin. We thank you for your patience. So here's the good news. The tournament director has been in touch with one of the scoring judges, the one we're missing, who tells him that they're in the waiting room. There's nobody in our waiting room as far as I can see. But the great news about this is that means it's really easily fixable. The judge is probably in the waiting room for like the wrong day. The reason that's good news is it means they're not like asleep somewhere. And we should be able to get them pretty presently. So we're working on it. And again, we thank you for your patience. Hello, welcome. Okay, Ms. Rodriguez Markel, are you good? You good? Yeah, you're with us? Okay. Great, thank you. I want to welcome everybody to the next round of the tournament. Again, my name is Sarah Jacobson. I thank you for your patience in getting started. I think we have everybody we need at this point. I'll ask our scoring judges, do you see any conflict here? And by that, I mean, do you know anyone on either team to a degree that will affect your ability to provide an unbiased evaluation?
No. This is Dane. No.
Okay, great. Wonderful. Well, then I think it's time to get started. I'm going to assume that the witnesses are pre-sworn. I'm supposed to swear in all the lawyers here, which is a little weird, but whatever. Okay. Counsel, I'll ask you to raise your right hand and please indicate by saying I do if you swear to abide by the rules of this proceeding and conduct yourself in a manner that is honorable to this forum.
I do.
I do.
Excellent choices. All right. We'll now call this case to order. Let's start with just entries of appearance. Good morning, counsel.
Good morning, Your Honor. My name is Rachel Maxwell, and along with my co-counsel,
Good evening, Your Honor, or good morning, Your Honor, Corey Posey.
Nice.
we represent the plaintiff in today's case. May my co-counsel tender our notice of appearance via chat?
Sure, that'd be useful. Thank you. Defense.
Good morning, Your Honor. CJ Bauer with Esther Veloz. Together, we have the privilege to represent Karen Basia, the defendant. Pending housekeeping matters from the plaintiff, Your Honor, the defense has pretrial motions to be heard.
Okay, great. Well, let's, you know what? Oh, they are making me do housekeeping first. All right. Not my favorite, but not my tournament. So we'll hear housekeeping matters first. Let's take care of the housekeeping.
Your Honor, the plaintiff confirms that you have copies of all the pertinent materials and exhibits with base number.
I do. Yep, I have them. I don't have them printed out. I have them PDF on my machine, so it may take me a couple minutes to get where you are. So I ask for your patience if I need it, but yeah, I have them.
Perfect. And we would ask your permission to reference the exhibits in this file by the last two digits of the Bates number at the bottom right-hand corner whenever we're referencing them for opposing counsel and witnesses to get to.
That's fine. Yep.
Now, we would also ask Your Honor's preference on how we keep our cameras when we're not examining a witness or objecting. Should we keep those off at that time?
Right. So during the trial itself, the person who is doing the thing should keep their camera on. If you are crossing, essentially, like if you are opposing counsel on a witness, you can keep your camera on. That's fine. Right. So is that clear for people? If you're doing the thing, or if you're opposing the witness, or if you are the witness, have your camera on, and otherwise have it off.
Yes, Your Honor. We would also ask that we be able to enter into evidence exhibits during opposing counsel's case in chief if necessary, because we can't call rebuttal witnesses.
Of course.
Thank you, Your Honor. And then we would also ask how Your Honor prefer we handle objections. Specifically, should we ask for constructive sidebar before arguing grounds, or assume that we are at constructive sidebar when we object?
You know, not every argument needs to be made at sidebar, so I'm going to ask for you to ask for sidebar when you want it.
Yes, Your Honor. And with that, we're ready to move on to motions.
Okay. I'll hear any additional housekeeping from the defense.
Yes, Your Honor. Does this jurisdiction follow the one advocate, one voice rule?
Well, so I don't know what you mean by that, but tell me what you mean and I'll tell you if yes or no.
Yes, Your Honor. The one advocate, one voice rule means that when an attorney is directing a witness, they may only object on cross, and the attorney that is crossing the witness may direct on the object, not like a tag team type objection.
Of course, I thought that was a universal rule everywhere. I'd be shocked if it were not. No, don't make objections for your partner. I'm sure your partner will do just fine.
Pursuant to the rules of this jurisdiction, we may not redact documents before trial. In order to save time, may we constructively redact documents if that does come up today?
You may.
And for impeachment purposes, would Your Honor like us to share the deposition or report on the screen, or shall we presume that the witness has a copy of this information?
You know what? It'll probably be easier for you if I don't make you put it on the screen. So let's go with easier.
And at this time, we would like to constructively invoke the rule of sequestration under Federal Rule of Evidence 615, excluding the defendant, Karen Basia, and the plaintiff.
Okay. Response from the plaintiff, any objection?
No, Your Honor, we're fine with sequestering the other witnesses.
Okay. All right. They are sequestered.
That concludes our housekeeping matters, Your Honor. Would you like a brief summary of the case?
I would.
This is a wrongful death case in which the plaintiff, Cam Donaldson, alleges that the defendant, Karen Basia, killed Lou Donaldson and forged his will. During this trial, it is our position that Lou Donaldson is in fact not dead and is in Costa Rica with his mistress.
Your Honor, the only thing that I would add to that is, just for clarity's sake, Mr. Donaldson was married to the defendant, Ms. Basia, at the time, and the plaintiff, Cam Donaldson, is Mr. Donaldson's daughter. So,
got it. Okay. Are there motions or substantive motions?
yes, Your Honor. The plaintiff moves to exclude any mention of the police investigation into Lou Donaldson's disappearance, pursuant to Rules 802 and 701C. By way of background, the police still have an active investigation into the whereabouts of Mr. Donaldson, the victim in this case. We anticipate that the defense will try and introduce testimony about this police investigation, specifically testimony about why the police have not arrested the defendant. We believe that this will go to the conclusions of the police and would therefore constitute an improper opinion. Further, since nobody that was involved in that investigation will be testifying today, Any mention of this investigation would be inadmissible hearsay with no recognized exception.
Okay. Defense, is this a motion you oppose?
Yes, Your Honor, we do oppose this motion. Taylor Pride, the expert witness on the plaintiff's case in chief, and Chris Renard, the expert witness in the defendant's case in chief, both looked in or attempted to look into the police investigation. And through their investigation, they found that Mr. Donaldson's body was never found, that Ms. Basia is not a suspect. This information is highly relevant to the case in chief, to our case in chief, Your Honor, as it goes to show that Lou Donaldson is not in fact dead and that Ms. Basia did not kill him. The probative value of this evidence substantially outweighs the risk of unfair prejudice. Additionally, Your Honor, although the evidence does not come in through scientific knowledge of the witnesses, both witnesses have experience in law enforcement. Chris Renard used to work at the Pioneer Police Department, and he's also a claims investigator. As a claims investigator in Summit Life Insurance Company, he looks into police reports, he looks into investigative interviews, and Taylor Pride is a private investigator who has, I believe, almost 18 years of experience in law enforcement. So this information is highly relevant, Your Honor.
Okay, and well, but it wasn't a relevance objection. So tell me why you're talking about relevance.
Well, Your Honor, although it is hearsay, an expert can testify as to otherwise inadmissible evidence under Federal Rule of Evidence 703 if the probative value substantially outweighs the risk of unfair prejudice. So although it will not come into the truth of the matter, it is highly relevant, Your Honor.
Okay. Counsel, I assume you have a response?
Yes, Your Honor. I don't expect that either side will be tendering their experts or will be successful in tendering their experts in any field that reasonably relies on police investigation information. Therefore, this information would not come in under 703. Further, even if they are able to tender their expert in some area that would allow it to come in, this information is inflammatory and would clearly be taken for the truth of the matter, and would that prejudicial value would substantially outweigh the probative value that it has.
I tend to agree in terms of the balancing test here in 703. I'll allow testimony that there is an ongoing open police investigation, but no further detail than that.
Thank you, Your Honor. And for our second motion, the plaintiff moves to exclude any mention of the fact that the victim's pilot's license was suspended at the time of his disappearance, pursuant to Rule 802. By way of background, some of the witnesses have indicated that Mr. Donaldson's pilot license was suspended whenever he went missing. We expect the defense will try to introduce testimony about this to try and show that Mr. Donaldson might not have filed flight plans at the time. Because this suspension was ordered by an administrative body and there's nobody from that administrative body testifying today, nor any admissible document showing that the suspension was ordered, any mention of it would be inadmissible hearsay with no recognized exception.
Is this a motion you oppose, defense?
Yes, Your Honor. Cam Donaldson, the plaintiff in this case, was her father's assistant. And with that, she had knowledge of flight plans being recorded or not being recorded, as well as her father's invalid pilot's license. That's why this evidence should come in. It's also highly relevant to the facts of this case to show that Mr. Donaldson, in fact, is not dead. In fact, it's our position as defense that Lou Donaldson flew a plane to Costa Rica and disappeared along the way. The fact that he didn't have a pilot's license is highly relevant for that value, for that purpose, Your Honor. The probative value doesn't outweigh the prejudicial effect, and Cam Donaldson had personal knowledge to the fact that her father never registered his flight plans or rarely ever did, and that Mr. Donaldson's pilot license is suspended, Your Honor. Although there's no one from the agency to report that, it is something that Cam Donaldson had personal knowledge to.
What's the personal knowledge? What's the foundation for the personal knowledge that Cam Donaldson had about the pilot's license? How does Donaldson have that? Is that something someone said to Donaldson? Are you able to lay any foundation as to beyond just like that they kind of knew it?
Your Honor, Cam Donaldson was her father's assistant for over 20 years. And with that, she has knowledge of his books and records, as well as, his personal life. Okay.
Without greater foundation as to how she'd have that knowledge, that motion is granted
Thank you, Your Honor. With that, we're ready to move on to opening statements.
Okay. I imagine the defense will have a thing or two to say. Before we do that, though, defense, do you have any substantive motions?
Yes, Your Honor. The defense seeks to exclude any fact, evidence, or testimony related to a temporary restraining order filed by Lou Donaldson against Ms. Basia. Under Federal Rule of Evidence 802, it is inadmissible hearsay. It is also unfairly prejudicial to Ms. Basia. The temporary restraining order was filed nearly 2 months before Lou Donaldson disappeared, and it was denied by this court.
Okay, well, not by me, but by some court, I'm sure. Is this a motion that you oppose, counsel?
Yes, Your Honor. And I'll address first the existence of the restraining order itself and any mention of it, and then I'll get into the allegations and why they should come in. So the restraining order itself and the existence of it won't be used for the truth of the matter asserted, but rather the effect on the listener. The listener in this case being the defendant when she became aware of it, and the effect being the motive that it garnered for her to commit this crime. Regarding
the motive, hang on, counsel. You're saying that the motive for a murder is because there's a temporary restraining order against her, which made her so angry that she killed her husband?
So it goes to a larger idea that because there were rising tensions in the marriage and Mr. Donaldson was threatening to leave the defendant, at that point, she realized that she needed to secure his wealth and commit the crime that she did.
Okay, all right.
And then regarding the allegations that are within the restraining order, those also come in under 8033 because they show Mr. Donaldson's state of mind at the time, that he was seeking a divorce from the defendant, that he was scared from the defendant, and that the defendant had threatened his life. This is relevant because this restraining order was taken out 2 days before this purported last will and testament was drafted. And so his intent at the time, 2 days before that, to distance himself as much as possible from the defendant goes to the idea that he would not have drafted a will, giving her everything he owns just 2 days later. And
Yes, go ahead.
and if I can address her argument that it is more prejudicial than it is probative, I've just explained essentially why it is so probative, and I think that that probative value is not substantially outweighed by any unfair prejudice that it would have.
Okay, response.
Your Honor, if I may pull up the temporary restraining order so you could see it.
Sure.
Your Honor, under Federal Rule of Evidence 8033, that rule expressly excludes statements made off of memory. Statements 1 and 2 are statements based off of memory, Your Honor, as well. It doesn't show that Lou Donaldson was in fact seeking to file a divorce in the future. It's a present statement made. It's unfairly prejudicial, Your Honor, as this temporary restraining order was denied by a court, meaning that there was no grounds for to grant the temporary restraining order. Additionally, Your Honor, it was made 2 months before Mr. Donaldson's disappearance. We believe that this information would be highly prejudicial and also would go to show that because Ms. Basia allegedly threatened to kill her husband, she would likely do so 2 months later, Your Honor. We stand by our argument that it is unfairly prejudicial, and the probative value of that does not substantially outweigh the prejudicial effect.
Okay, you can take that down. Thank you. But seeing that was useful to me in terms of the 403 issue here, which is really where my ruling is going to fall. I'll allow evidence that there was that the decedent, that whatever his name is, whether he is dead or missing, filed for a temporary restraining order and that was denied, but not the contents or allegations therein.
Just to clarify, Your Honor, can we mention the date of the document for those purposes? Perfect.
Yep.
Thank you.
Your Honor, the defense seeks to exclude any fact, evidence, or testimony related to a statement made by Exotic Bob. Exotic Bob is an unavailable witness in this case, and he prepared a recording from prison. In that recording, Exotic Bob talks about an illegal deal that he allegedly had with Ms. Basia to illegally import large cats, lions, leopards, That deal is not relevant to the issue in this case. Exotic Bob is not a party to this case. This case is about a wrongful death. We ask that this court exclude any testimony about an illegal deal, as it is unfairly prejudicial. And we believe that it will invite the jury to make an improper decision based off of that testimony.
Okay, and counsel, so let me just make sure that I understand the scope of your argument. Is it that you're moving to exclude the entirety of that statement or only the portion of the statement about the illegal deal?
Yes, Your Honor, only the portion of the statement that talks about the illegal deal. If opposing counsel wishes to play the rest of the video, we are okay with allowing the rest of the video. However, any mention of an illegal deal to illegally import lions and leopards should be excluded.
Is that a motion you oppose, counsel?
Your Honor, so long as there will be no later objection to the rest of the video coming in, if that is truly their only objection is to that one paragraph, then we don't have any problem with that.
Well, I would assume that they'd bring up any and all issues they had with it now, as I invited them to make sure that I understood the scope of it. But things change during a trial, so I'm not going to say you can't ever bring up any other objections as to the rest. Like, I'm not going to do that. But it sounds like there's no opposition to that. I want to make sure we're really clear about the contours of that ruling, though. Is there a specific paragraph or line that excludes, just so that everybody is clear that the lines are really, really clear? And give me just a moment so that I can pull it up on my screen beside us here as we talk.
Your Honor, it's a paragraph that starts with, you see it was 2 years.
Can you give me the page number?
Yes, one moment. It's page 30 in the trial packet, and the statement is on page 1 of Exotic Bob's transcript.
Okay, got it. Thank you. I'm here. Okay. And so which paragraph are we talking about? Is that the third paragraph?
Essentially the fourth, the one that says, you see it was 2 years, 2 weeks to the day, that entire paragraph.
Okay. So, and anything beyond that paragraph, or that's the paragraph?
That's the paragraph, Your Honor.
Okay. Is that clear to the plaintiffs then?
So, Your Honor, I am fine with that specific paragraph coming out, so long as there is not a later objection that the following paragraph can't come in because there's not a statement against interest that is at play. If they're planning on arguing that this should be excluded based on hearsay, then I would want to be able to argue that this video is a statement against interest, and that paragraph, as it lays the ground for it being a statement against interest, I would want to be able to enter that in with it if they object to that later.
Yeah, I would imagine that's not what they're doing. I would imagine that they're not trying to game this by getting an admission, a concession out of you now to then say, no, they can't go back on it. I assume that that's the case here.
We have no intention, Your Honor, to make a later objection. We understand that the subsequent paragraph includes a party opponent admission as well. We have no intention to object to that paragraph.
Okay. All right, good. Then the lines, I think, are clear. All right. Anything else from the defense before we get started?
No, Your Honor.
Okay, great. Then I think we are ready for opening statements. We'll hear from the plaintiff.
Yes, Your Honor. May I have just a moment to set up the virtual well?
Of course. The virtual well. Huh, I like that. That's good.
May it please the court, counsel, members of the jury. We are here today because Lou Donaldson is not. Lou Donaldson is not here today because his wife, the defendant, killed him and forged a will declaring herself the sole heir to his fortune. Today we are here because Mr. Donaldson's daughter wasn't just deprived of her inheritance. More importantly, she was deprived of her father. And since there's nothing you can do today to bring her father back, Miss Donaldson simply wants what rightfully belongs to her family. And she wants the defendant to finally be held liable. Good morning. My name is Corey Posey, and I, along with my co-counsel Rachel Maxwell, have the privilege of representing Mr. Donaldson's only surviving child, Cam Donaldson. Now, before we get to exactly what happened to Lou Donaldson, let me tell you a little bit about him. Lou Donaldson started from the bottom. He had little formal education, but an excellent will to succeed. He began his career in sales, eager to earn money for what he was truly passionate about. And he did it. Lou Donaldson opened the Wild Wildlife Big Cat Sanctuary, and he went from sales to rescuing exotic animals. Mr. Donaldson had a soft spot for these big fluffy creatures, and you'll learn that he shared this love with his daughter. Miss Donaldson followed in her father's footsteps, and she spent nearly every day at her father's side at the Big Cat Sanctuary. They even joked that she knew his business better than he did. Life was the cat's meow for Mr. Donaldson and his family. That is until the defendant came prowling into their lives. You see, years ago, late one evening, Mr. Donaldson was driving down the road when he noticed a lovely young hitchhiker. He becomes curious. Who is this beautiful woman? And what is she doing all alone on these streets so late at night? His curiosity leads him to offer her a ride, and it turns out to be love at first sight, but members of the jury, as the saying goes in this case, curiosity really did kill the cat. Now, Mr. Donaldson married the defendant, and for 11 years, he shared his home, his wealth, and even that big cat sanctuary with her. But you will learn that things took a turn for the worse. The couple began arguing so much that Mr. Donaldson decided he wanted a divorce. Things actually got so bad that you will learn Mr. Donaldson took out a restraining order against the defendant. You'll learn the defendant came from nothing, and suddenly her husband's wealth and that big cat sanctuary, which she had come to adore, was slipping right through her fingers. And shortly after that blowout argument, you will learn that Mr. Donaldson was seen alive for the very last time. On August 17th, 2012 at 6 p.m., he packed up to leave the office at the end of another Friday, and he yelled over his shoulder to his daughter, inviting her to supper on Sunday. But little did Miss Donaldson know, that Sunday supper would never come. Just a few days later, Mr. Donaldson's van was found abandoned at an airstrip 40 miles away. Now, you will learn he was an experienced pilot, but he didn't store any of his planes at this particular airstrip. And even more suspicious, he was blind as a bat without his eyeglasses, yet the only pair he owned was found in that abandoned van. Mr. Donaldson vanished without a trace. And you'll learn that no body was ever found, but members of the jury, you'll also learn that the defendant had every means to make that possible. Now, Miss Donaldson will take the stand later today, and she'll tell you about the devastation that followed. She'll tell you how that following Monday morning, when she went into work, the defendant already knew her father would not be returning. So she fires Miss Donaldson on the spot. Miss Donaldson had been a crucial part of her family's business for over 20 years, and suddenly she was left not only unemployed, but in the dark as to where her father was and to what the defendant did to him. 5 long years go by, and Miss Donaldson receives no answers. But you will learn all those years, the defendant was just biding her time. You see, legally, she had to wait 5 years to have Mr. Donaldson declared dead in order to collect his insurance payout of $5 million. You'll learn that she did just that. 5 years to the day after Mr. Donaldson was declared dead, she cashed in. And in doing so, you'll learn that she turned over what she claimed was Mr. Donaldson's last will and testament. But Ms. Donaldson will tell you this was not her father's original, genuine will. Later today, you'll hear from Investigator Taylor Pride. She's an expert in forensic document examination, and she reviewed this purported will and will tell you that not only is the language of the will suspicious, but Mr. Donaldson's signature was forged. Now, members of the jury, when a will is created, the owner of that will must sign it, verifying that the contents are true, that that is exactly what he wants to happen upon his passing. Who will take over his business, where his money will go, who will live in his home, and so on. And then witnesses must sign the will as well, saying that they saw the owner sign and that owner agreed everything in that will was true. You will learn that Mr. Donaldson's will had only 2 witnesses, one of whom was the defendant, the one person who stood to gain everything upon the execution of that will when her husband disappeared. And the other witness later confessed to never actually having seen Mr. Donaldson sign that will. She said she did because she was coerced by the defendant. The evidence will show that that will was forged, and it will be your job to decide who forged that will and why would they forge it. But members of the jury, to make your job easier, all those answers lie with the defendant. Now, we are here today because Cam Donaldson has brought a suit against the defendant for the wrongful death of her father. And in order for her to prevail today, we must prove the following: that Lou Donaldson is dead, and that's because of the defendant. And that Ms. Donaldson suffered injuries, damages, or losses as a result of her father's death, and that's because of the defendant too. Now, we have to prove this to you today by a preponderance of the evidence, which is just a fancy term for saying that something is more probably true than not. We are confident that after you see the facts and the testimony and the evidence today, you will have no choice but to believe that the defendant killed her husband and caused all of Miss Donaldson's heartache. Lou Donaldson's curiosity about a lovely young hitchhiker one evening eventually became his downfall. What he expected to be a life full of love and laughter and big furry rescue cats actually became a life tragically cut short. And the business that he worked so hard to build from the ground up, falling into the hands of the woman he was seeking to divorce, a woman who threatened to kill him, a woman who ultimately caused his untimely death. What Miss Donaldson really wants is her father back. But you can't give that to her today because of the defendant's actions. All you can do now is to return to Miss Donaldson what her father intended to give her, and in some small way, hold this defendant responsible for her despicable actions.
Objection, argumentative.
I assume the counsel's wrapping up. That's overruled.
Members of the jury, we are here today because Lou Donaldson is not. And the evidence will show Lou Donaldson's not here today because the defendant made sure of it. So at the conclusion of today's trial, we will ask that you hold the defendant liable.
Okay, thank you, counsel. We'll hear from the defense.
May it please the court.
You may proceed.
Your Honor, opposing counsel, members of the jury. Lou Donaldson was a risk taker. Now Karen Basia is the victim. Karen Basia lost her husband, her best friend, and her soulmate. We are here today because Lou Donaldson's will left everything to his wife, Karen Basia, and his daughter, Cam Donaldson, refuses to accept that. Now, to understand why Lou Donaldson would leave everything he had to his wife, Karen Basia, we must look at their love story. Karen Basia was all alone walking down the side of the road, admittedly at a low point in her life, when Lou Donaldson appeared like a knight in shining armor and swept Karen Basia off of her feet. Now, Karen Basia felt, why is this happening to me? Things like this don't happen to me. And she was right. Because Karen came to find out that Lou Donaldson had a wife and a child at home. But Lou Donaldson was charming, and Karen Bessilla stayed. And because she stayed, Lou Donaldson and Karen Bessilla developed a one-of-a-kind love, an inseparable bond. Lou Donaldson eventually divorced his wife. And one day he asked Karen Bessilla the big question, a life-changing question: will you marry me? Of course Karen Bessilla said yes. She was over the moon. Lou Donaldson and Karen Bessilla built their wild, wild life, their big cat family together from that day on. And they lived this life day in and day out for years. Lou Donaldson's family was not happy. They treated Karen Bessilla like an outsider and never gave her a chance. And years went by and the family stepped to the side. But Karen Bessilla continued working at Wild Wild Life. Because to Karen Bessilla, this wasn't a paycheck. This wasn't a means to an end. This wasn't a job. This was her passion. This was her life's work. Something that she did with her husband every single day for a decade. And they loved it. Even after over a decade of marriage, Karen Bessilla felt like the luckiest woman in the world. But sometimes love blinds people. As you will come to find out, Lou Donaldson was a private man. Nobody ever really knew what Lou Donaldson was doing, and he liked it that way. You see, Lou Donaldson had money. And with that money, he bought planes, and he would fly wherever he wanted, extravagant trips around the country. And most of the time, he was going to Costa Rica. He was going to Costa Rica to live his other life that nobody knew about. Nobody except for Karen Bessilla. Karen Bessilla came to find out that her husband had a mistress in Costa Rica. Of course she was upset, devastated. Her husband of over 10 years had a mistress. This is something that the couple was working through because Karen Bessilla has a big heart, a forgiving heart. Nobody ever really asked questions when Lou Donaldson went on these trips because he always came home. Until one day, Lou Donaldson didn't come home. The last traces of Lou Donaldson are seen at an airstrip 40 miles away from his home. And inside of his van were his glasses and his keys. And his glasses and his keys are sitting there in his van. And while his glasses and keys are sitting there collecting dust, Karen Bessilla was on the other side of Pioneer County. She began to worry. Karen began to worry because she hadn't heard from her husband. Karen began to worry because she had no idea where her husband was. And because of that, Karen had to take over Wild Wild Life. Karen had to take over Wild Wild Life because Lou never came home. And because Karen took over Wild Wild Life, she had to make some tough decisions. And those decisions have led us right here to this courtroom today. The plaintiff filed this case, which means they have the burden, the preponderance of the evidence. They received this burden the moment they filed this case, and it has followed them all the way to this Zoom courtroom and is currently covering their laptop screen. That burden does not go away, members of the jury. And they have the burden to prove to you more likely than not that Lou Donaldson is dead. Lou Donaldson is dead because Karen Bessilla killed him, and that Cam Donaldson suffered injuries because Karen Bessilla killed Lou Donaldson. Now, remember the 4 elements that the plaintiff told you about during their opening statement, the 4 things that they must prove. The 4 things that they must prove to you. And if they fail to prove just one of these things to you, members of the jury, they have not met their job. They have not done their job. And it is your job to hold them accountable when they have not done that. Now, during the course of this trial, you're going to hear evidence and you're going to see evidence and hear testimony. And you're going to hear from Karen Bessilla, Lou Donaldson's wife and his best friend. She's going to walk us through Lou Donaldson's disappearance from her perspective and how she still hopes every day that her husband will walk back through that door and end this nightmare. She's going to tell us about their love and their life and how they lived together for years. She's going to tell us about the money that Lou Donaldson left her, the money he left her to continue running Wild Wild Life, to keep their passion alive. Then we're going to hear from Chris Redart. Chris Redart is a document examination expert with over 20 years of experience. Now, Chris Redart works for Summit Life Insurance Company. This is the company that paid Karen Bessilla her husband's life insurance policy. He's reviewed hundreds and hundreds of wills during his career, and that has allowed him to determine when something is forged and when something is not. And he used that expertise in this case to determine that Lou Donaldson did sign that will, that the will was not a forgery. And Chris Redart is also going to talk about the investigation he conducted into Lou Donaldson's disappearance and what actually happened to Lou Donaldson. Then we're going to see a video from Exotic Bob during the course of this trial. While Exotic Bob is not going to be here, you're going to see a video of him. And in that video, Exotic Bob is going to be in a jail cell. And the evidence will show that Exotic Bob is in jail because Karen Basia put him there. He does not like Karen Basia. At the end of this trial, you will have to render a verdict that must be supported by the facts and the law. And we are confident that at the end of this trial, you will find Karen Basia not liable for the wrongful death of her husband, because Lou Donaldson was the risk taker, and now Karen Basia is the victim. Thank you.
Okay, thank you, counsel. Just a quick note. I don't know if counsel exchanged exhibits or talked about use of exhibits in opening before the round, but you really should do that. And if you're going to be using exhibits in an opening, I recommend you ask permission of the judge or give the judge a heads up in housekeeping so that that could be addressed before the speech itself, so that if there were any objections, we could deal with that in a way that wouldn't interrupt your speech. So just a note for kind of future thought, okay?
Your Honor, understood. We had agreed on pretrial, and opposing counsel did see my presentation. I apologize for not showing it to the bench before my opening statement.
That's okay. I would just want to know that conversation had happened and not be surprised that you were using the exhibits in opening. But I certainly understand in an online forum why you might want to do that. Anyway, with that, plaintiff, why don't you call your first witness?
Yes, Your Honor. The plaintiff calls Cam Donaldson to the stand.
Okay, Ms. Donaldson, you've been sworn.
Yes, ma'am.
And counsel, you may proceed.
Good morning. Can you please introduce yourself to the court?
Yes, my name is Cam Donaldson.
Ms. Donaldson, what is your relationship to Lou Donaldson?
I'm his only child.
And as his only child, were you close?
Yes, we were very close.
Would you recognize a photo of your father if I showed it to you today?
Yes, I would.
Okay, Ms. Donaldson, I'm referring to you what was previously marked as Exhibit 3. I'm referring opposing counsel to the same. Ms. Donaldson, just let me know when you have that up in front of you.
Yes, I have it up in front of me.
Okay, do you recognize that?
Yes, I do.
And how do you recognize that?
It's a photo of my father and I from when I was a young girl.
Is that a fair and accurate representation of that photo?
Yes, it is.
Your Honor, the plaintiff moves what was previously marked as Exhibit 3 into evidence as Plaintiff's 1.
Let's just call it 3 rather than then calling it 1. I'll never be able to keep it all straight. Any objection?
No, Your Honor.
Okay, it's in.
Okay, permission to publish to the jury.
You may.
And just for going forward, Your Honor, would you like us to continue asking to publish or just to assume that we can because of this forum once it's admitted?
Yeah, let's save the time and assume that once it's been admitted, you can just publish it as needed. If you want to republish something like later in the case, just ask to republish it.
Sure. Okay, Ms. Donaldson, will you just let me know that you see that photo in front of you?
Yes, I do.
Now, you were pretty young in this photo, but does it still accurately represent the relationship you had with your father before he died?
Yes, it does. We were already close when I was a little girl, and then Dad brought me into the business to help him run it together before he died. He even joked that I knew more about the business than he did.
Thank you, Ms. Donaldson. Now, what was it that your father did for a living?
He owned the Wild Wildlife Big Cat Sanctuary. He had such a big heart and loved animals. He saved lions, tigers, leopards, you name it.
And was that always his career?
No, he started off in sales. He was completely self-made and had little formal education, but he worked really hard and was finally able to do what he always wanted to, which was start Wild Wildlife and save those big cats.
Now, after spending 20 years in the business with your father, are you aware of the value of his business before he died?
Yes, I believe it reached around $5 million.
And are you still employed at the Big Cat Sanctuary?
No, unfortunately, Karen Baja fired me shortly after my father disappeared.
Okay, we'll come back to the firing in just a moment, Ms. Donaldson, but first, can you tell us who is Karen Basia?
She was my father's wife when he disappeared.
How long had they been married at that point?
I believe about 10 or 11 years.
And did you and the defendant get along?
No, I believe she's the reason why my father is dead.
Objection, speculation.
Response.
Yes, Your Honor, this is just Ms. Donaldson's rationally based opinion based on all of her observations with her father and the defendant.
Yeah, not quite. Objection sustained.
Now, why was it that you and the defendant did not get along?
Well, my dad left my mom for Karen, so admittedly we got off on the wrong foot, but we were certainly civil to each other at work, but I never really came around to liking her the whole time that they were married.
Now, you said that your father left your mother for the defendant. Did that affect your relationship with your father at all?
It didn't really. I mean, I was already an adult and was able to see my parents as adults that lived their own lives. It didn't change my relationship with either one of them.
Okay, now earlier you said the defendant fired you. Does that mean she also worked at the sanctuary?
Yes, that is correct.
And were you able to observe your father and the defendant together because you were there as well?
Yes, pretty much every day.
Now, working with both your father and the defendant, what, if anything, did you observe about the relationship?
At first, he was obviously a total smitten kitten with her, but as the decade went on, they began to drift apart. Before he died, things got pretty bad between them.
Well, what was it that you observed that made you believe that?
They fought a lot.
Did you observe these fights personally?
Yes, I did.
And do you remember any in particular that stood out to you?
Yes, a couple of weeks before he disappeared, I heard them having a pretty bad fight at the office.
And what was that bad fight about?
My dad wanted a divorce.
Were you able to observe the defendant's reaction to this?
Yes, I was.
Can you tell us about that reaction?
Oh, she was just furious.
And what about your father? What was his demeanor throughout all of this?
When I tell you I've never seen my dad like that, he was so upset, red-faced, yelling. I mean, that was the most upset that I had ever seen him.
Did you stick around for the remainder of that argument?
Yes, I did. I was there when my dad stormed out of the office.
And what, if anything, happened when your father stormed out of the office?
He was so worked up. He stormed out and realized that I had been there and that I had heard the whole thing. And he shouted at me, if anything ever happens to me.
Objection, hearsay.
Response.
Yes, Your Honor, I believe I've laid the foundation that this was an excited utterance on behalf of Mr. Donaldson.
I'll hear from you, Mr. Bauer, if you have anything else to add to that as to whether that foundation has been laid.
Your Honor, we have not heard when she talked to her father, if it was after the argument, way after the argument, or about the state of her father. We heard that he was red-faced and yelling inside of the office or wherever he was, but we have no idea where Ms. Donaldson was positioned at this time or what was going on.
Okay, I think the foundation is sufficient. The objection is overruled.
I'll re-ask my question, Ms. Donaldson. What, if anything, did you observe from your father when he stormed out of the office?
He was so worked up. He stormed out and realized that I had been there and that I had heard the whole thing. And he shouted at me, if anything ever happens to me, have the police look into Karen because she will be the one responsible for my death.
Now, I would like to go ahead and get into your father's disappearance. When was the last time that you saw him alive?
That would have been Friday, August 17th, 2012.
And can you describe that last interaction for us?
He was leaving work in the evening and yelled goodbye to me over his shoulder and said he'd see me Monday, unless I wanted to come over for supper that Sunday.
Did you see your father again after that interaction?
No, I didn't.
Do you have any clue as to where he may have gone after he left work?
No, but his van was found a few days later at an airstrip with his keys and glasses inside.
Now, you said this was found at an airstrip. Was your father a pilot?
Yes, he was.
Did your father ever fly out of this particular airstrip?
No, that airstrip was 40 miles outside of town. I'd never known my father to use it. He didn't store any of his planes there either.
And you mentioned that his glasses and keys were found inside. Why was that significant to you?
Well, my dad is blind as a bat. He can't fly without those.
And were you aware of any plans that your father may have had to leave the country?
No, none.
Did he typically tell you if he was going to fly somewhere?
Yes, he always told at least me or my mom so someone would know where he was. And like I said, we spent every day together, so it would have become pretty apparent that he wasn't there if he didn't tell me.
Now, Miss Donaldson, were you aware of your father having a mistress?
No, I wasn't. And like I said, I didn't get along with Karen, so there would have been no reason for him to hide that from me.
Now, you also mentioned earlier that your father left your mother for the defendant. When he did that, did he move out of his home and move in with her?
No, she moved in with him.
Did he leave his business for the defendant?
No, he just brought her into the business.
Did your father leave you when he met the defendant?
No, nothing changed between my father and I when he married Karen.
Now, Ms. Donaldson, I'd like to talk about that dinner that you mentioned earlier. When was that supposed to occur?
That would have been Sunday, August 19th, 2012.
And did that dinner occur?
No, and that's when I started to become really worried.
Why were you worried?
Well, like I said, we had plans, and it wasn't just like him to not show. I hadn't heard from him all weekend, and he didn't tell me if he was going anywhere. On top of that, something weird had happened earlier in the morning at the office.
What do you mean by weird?
Well, at around 6 a.m., the alarm went off, and I lived pretty close. So when I drove over, I found the gate lock cut and the back entrance to the office damaged.
Okay, Ms. Donaldson, did you happen to take photos of the scene that you just described?
Yes, I did.
Would you recognize those photos today?
Yes, I would.
Ms. Donaldson, I'm going to refer you as well as opposing counsel to what was previously marked as exhibits 4 and 5. Let me know when you have those up in front of you. Okay, Ms. Donaldson, do you have those in front of you?
Yes, I do.
Okay, can you tell us, do you recognize those?
Yes, I do.
And how do you recognize them?
It's a photo of the cut lock and the damaged back entrance.
And is that a fair and accurate representation of those photos?
Yes, it is.
At this time, the plaintiff moves to include exhibits 4 and 5 into evidence.
Any objection?
Yes, Your Honor, lack of foundation. Ms. Donaldson did not take these pictures. I just asked that the questions be rephrased.
Okay, I'm not going to dictate how they phrase their questions, but counsel for the plaintiff, I'm hearing that there's an insufficient foundation because Ms. Donaldson did not take these pictures. What is your response?
Your Honor, it's our response that the defendant did in fact take these photos when she showed up at her father's business. There's no evidence that anyone else took them.
Does it matter who took the photos?
I don't believe so. We're just asking about what she found at the office that day, and she's already testified that she's seen this site.
Yeah, so long as the photos fairly and accurately show what the scene looked like that day, it doesn't matter who took the photos. Anybody can take the photos. The objection's overruled and the photos are admitted.
Yes, Your Honor. Now, Ms. Donaldson, considering you spent every day at the office and that your father owned this business, why did it worry you when you saw this scene?
Well, I knew that my dad stored important things in the main desk, which was my desk.
What kinds of things?
He had his will in a lockbox. He kept it in the bottom drawer of my desk, and that's where he had always kept it.
Now, when you saw this scene, did you actually attempt to enter the office?
I was about to, but I was stopped short by Karen.
Can you describe more about meeting the defendant at the office that day?
I saw Karen was coming out of the office, and she was smiling from ear to ear, carrying my father's lockbox.
Was it unusual to see the defendant at the office at this time of day or on the weekend?
Maybe if my dad was with her, but this time she had clearly broken in.
And what, if anything, told you that she had broken in besides that lockbox in her hands?
Well, in addition to the cut lock and the damaged back entrance, there was a man with her and he was carrying lock cutters.
Objection, speculation.
Speculation that the man was carrying lock cutters or that the man was with her. What's the speculation, counsel?
Your Honor, speculation as to the fact that Karen Basia broke into Wild Wildlife that night.
Yeah, but counsel, that was like 3 questions ago. I mean, I would have sustained it at the time, but we're past that. We're a bunch past that. So the question that's currently here is that the man was carrying bolt cutters and was with her. So the objection's overruled as untimely now.
Now, Ms. Donaldson, I do want to get more into that lockbox in just a moment, but first, are you aware that your father was reported missing just the day before this incident occurred on August 18th?
I was made aware later, yes.
So you were not the one to report him missing?
No, at the point of the break-in Sunday morning, Karen was the only one alleging that my father was missing at that point.
Okay, let's go back to that lockbox. First, the will that was in that lockbox, had you ever seen it before?
Yes, I had.
And was that the will that was turned over for the execution of your father's estate?
No, it wasn't.
What was contained in the will that was turned over?
It gave everything Dad had to Karen. Nothing to his daughter, who played a vital role in his business, and nothing for the animals that were so dear to him. And some weird language about if he should disappear.
Okay, Ms. Donaldson, we'll come back to that in just a moment. But first, everything you just mentioned, did that original will in the lockbox give everything to the defendant as well?
No, it would have divided my dad's assets equally between me, my mom, the sanctuary, and Karen.
And that language about disappearing, was that in the original will?
Of course not. Who puts "should I disappear" in their will?
Now, considering this whole scene that went down on Sunday, the following Monday, did you go into work with the defendant?
Yes, I did, but she fired me as soon as I walked in.
Was it odd that she fired you?
Yes, she didn't have the authority to do that. She didn't own the sanctuary. My dad owned the sanctuary, and Karen was the only person saying he was missing at this point.
So considering all of that, why is it that you left then?
I didn't want the drama with her. For all I knew, my dad would be coming into the office anytime and he would clear everything up.
Now, Ms. Donaldson, do you have any personal knowledge of whether or not the defendant benefited from your father's death?
I do, and she did.
How so?
She eventually took full control over the sanctuary. Legally, she had to wait 5 years to have my dad declared dead.
And did the defendant in fact do that?
She did.
When did she do that?
The exact day the 5 years ran out.
And what happened at that point?
She got the rest of everything he had. His entire estate worth $5 million, plus another $5 million from the insurance company based off of that new will.
Now, Ms. Donaldson, what is it that you came here for today?
I just want what rightfully belongs to my family, what Dad worked hard for, and for it not to go to the person who killed him.
And Ms. Donaldson, can you tell us, how has your father's death affected you?
It's turned my whole world upside down. It's been 8 years, but it hasn't gotten any easier. I think about him every single day. I got to see Dad every day and work with him at the sanctuary, but now I don't have my dad or a job. I can't even go to the sanctuary to feel connected to him or to carry on his legacy. It's all been really devastating for me and for my family.
Thank you for your testimony today, Ms. Donaldson. No further questions at this time, Your Honor.
Okay, Cross.
Yes, Your Honor. Ms. Donaldson, you were never promoted at Wild Wildlife.
No, I was my father's assistant for 20 years, but to me, it was the best job I could have had. I was really close with my dad, so I loved my job, and I did pretty much everything.
And during this 20 years, you were never made part owner of Wild Wildlife.
No, but like I said, I enjoyed my job. There was no better job that I could have had. I didn't want another job.
And you dedicated your entire life to this company.
Yes, I worked there for 20 years with my dad.
So naturally, being fired from this job upset you.
Yes, it did.
And you don't like Karen Basia because she fired you from that job.
No, I don't like Karen Basia because I think that she killed my father and was after his money.
So you hate Karen Basia.
No, I don't hate her. I dislike her. I believe hate is quite a strong word, but I guess I do not have very happy feelings towards her, if that's what you're trying to get at.
I'll ask you one more time. You hate Karen Basia, correct?
Sure, if you would like to qualify it as that.
And you hate Karen Basia so much that you wish she was eaten by one of her own tigers.
You know, we all say things that we don't mean, but I would never kill her. I know that's illegal.
Just to clarify, you have stated that you wish Karen Basia was eaten by one of her own tigers.
I believe I said that previously in my deposition. It was a little closer to when my dad died. And, you know, we all say things that we don't mean. I might have said that, yes, but I would never wish, I do not wish that she would be, I would kill her. That's illegal. And I know that's wrong.
Now, earlier you testified that your father was a pilot.
Yes, that's correct.
There are a lot of things you knew about your father.
Yes, that's correct. I was his
But there's some-
assistant.
But there's some things you didn't know about your father, correct?
Yes, that is correct.
You didn't know about all the planes he had.
I didn't know of every single plane he had, but I knew that he had planes. Yes.
You didn't know where all of these planes were kept.
I knew that he would never keep them at the airstrip where his van was found. It was over 40 miles away.
I'll ask one more time. You didn't know where all of the planes were kept, correct?
That's correct. Yes.
You didn't even know when your father was flying.
He always told me or my mom where he was going.
Let's talk about some things you did know about your father being a pilot. You did know that your father didn't register his planes.
Yes, that's correct. Unfortunately,
You did know that your father didn't log flight plans when he flew.
that was rarely, but yes.
And you know your father was reckless when he flew.
It depends on what you mean by reckless. Can you clarify that, please? I apologize.
No, it's okay. So your father usually flew alone
Yes, that's correct.
overseas.
Sometimes
That would be reckless.
my dad was an experienced pilot, so I don't know if I can qualify that as reckless. I don't necessarily have the personal knowledge on flying. I myself am not a pilot, so I don't know, but he did do that. Yes.
All right. Now let's talk about something you do know. You know your father's van was found at an airstrip before he went missing.
Yes, but that airstrip was again 40 miles away, and he didn't store any of his planes there because it was so far away.
Now, this is an airstrip where planes could be kept,
Yes.
an airstrip where planes could fly out of.
Yes.
Now, I want to talk about some things you told us during your direct examination. You told us that you took the photos of the lock in the gate on August 19th at Wild Wildlife.
Yes, that's correct.
Now, you didn't take any photos of Karen with the lockbox?
No, I did not. I didn't believe that that was necessary because the police followed me directly in, so I didn't believe that I needed to take a photo of them.
You didn't take any photos of the random person?
No, I did not.
You didn't take any pictures of the lock cutters?
No, I did not.
You didn't take any pictures of the empty desk drawer in your office?
No, I didn't believe that that would be necessary. It would just be a picture of my drawer, and I don't know necessarily what that would have proven.
You didn't take a picture of the drawer opened?
No, I did not. I
So
didn't.
just,
I'm sorry for cutting you off.
oh, I apologize, Ms. Donaldson. just-
Oh, I'm sorry again. Go ahead.
With Zoom, sometimes connection gets mixed up. I apologize. I'll re-ask it. Let's not jump over each
Sorry.
other's toes. I apologize. Now, just to clarify, the only two pictures you took that day were of the lock and the gate.
Yes, that's correct.
Now, you also talked about your father's original will,
Yes, I did.
a will that gave you 25% of everything he owned.
Yes, that's correct.
And that would be around $2.5 million.
Roughly, yes.
Now, today you're not seeking 25% of your father's estate, correct?
Yes, that is correct.
You're seeking your father's entire estate, correct?
Yes, I'm seeking my father's estate for me and my family and the sanctuary. That is correct.
Even though your father never wanted you to have more than 25%?
Well, I would have been happy with the original 25% that my father offered me, but unfortunately, I would even be happy with my father being here today. But unfortunately, my father isn't here today due to the actions of Miss Beja, and she got my dad's sanctuary, which is something that my dad worked hard for. I don't want it to go to the person who killed him. So yes, I am going for the whole thing because I believe that's what me and my family and the sanctuary deserves.
Now, Ms. Donaldson, you also testified that the original will did not contain the language "if I disappear."
Yes, that's correct.
You gave a deposition in this case, correct?
Yes, that's correct.
If you could pull that deposition up and show me where in the deposition it says that the original will did not contain the phrase "if I ever disappear."
Yes, it might take me a minute. Is that okay?
No problem.
Okay, 1 second. I have to pull up the deposition. I think I just scrolled past it on accident.
Counsel, do you have a page you can direct us to or a section maybe to make this easier?
Yes, Your Honor. One moment, I'm pulling out my trial packet.
I don't have the page number, I apologize, but I have the line.
Go ahead.
It's the question says, so what happened to the contents of the lockbox? And in the middle of the paragraph, the answer says, it was particularly laughable because it contained the phrase, if I should die or disappear. That language was never in his last will and testament before, and I've never seen that language in any other last will and testament. I don't have the exact page number, though. I apologize.
That's perfectly fine. No further questions.
Okay, any redirect?
No, Your Honor, may this witness be excused.
You are. Thanks so much, Ms. Donaldson. You're welcome to stay, but if you have other things you want to do with your Saturday morning, the court will understand. Plaintiff, anything further?
Yes, Your Honor, at this time, this is when we'll call our unavailable witness, Mr. Bob Exotic. May my co-counsel publish that video?
You may.
And at the end of that meeting, Karen Baja walked out of my office. She stopped, suddenly turned around, and she came marching back to my desk, and she leaned over and she looked me right in the eye and she said, "Exotic Bob," that's me, Exotic Bob. She said, "Exotic Bob, I swear if you double-cross me on this deal, I will do to you exactly as I did to my husband." She said, "There won't be no disappearance, no mythical flight to Costa Rica." She goes, "Your last supper will be you. I'll feed you to my kiddies just like I did him." And then she turned around and she walked out of my office. That's all I've got to say about that.
Okay, plaintiffs, call your next witness.
Your Honor, the plaintiff calls Taylor Pride to the stand.
Okay. Taylor Pride, you have been sworn, and counsel, you may proceed when you're ready.
Could you please introduce yourself to the court?
Yes, my name is Taylor Pride.
What do you do for a living, Ms. Pride?
I am a private investigator and forensic document examiner.
Okay, before we get to why we're here today, I'd like to talk a little bit about your background, Investigator Pride. Let's start with your career in investigation. How did that begin?
Yes, I started as a patrol officer with the Pioneer Police Department all the way back in 1998. And then just 2 years later, I was promoted to detective.
Do you still work with the PPD?
No, I was a detective for 16 years, and then I left to start my own private investigator firm.
How long have you had that firm open?
Since 2016.
Now, during the course of your career, what kind of crimes have you investigated?
Oh, I've investigated every kind of crime, everything from economic crimes all the way up to murder.
Now, I'd like to talk to you about your career in forensic document examination. Can you explain to us exactly what a forensic document examiner does?
Yes, I look at handwriting, usually signatures, to verify if they're authentic.
How long have you been doing this type of work, Investigator Pride?
Well, back when I was still at the Pioneer Police Department from 2002 to 2008, I was in the economic crime unit. And in that unit, we investigated a lot of forgeries.
Now, do you continue to practice in this area since leaving the PPD?
Yes, I do.
Do you have any certifications or training in this area?
Yes, back in 2002, I attended an extensive seminar held by the American Association of Handwriting Analysts. And there I learned how to analyze and compare handwriting.
Did you receive any accreditations in this field?
Yes, I also have, I went through an accreditation or a certification process with the American Board of Forensic Document Examiners, and that's the premier organization in this field.
Could you tell us a little bit more about that certification process?
Yes, it really breaks down into 4 parts. So first I had to submit my credentials and some references, and then I had to complete a proctored multiple choice exam. Then I had to do a practical exam and then an oral exam as well.
Now, since receiving this accreditation, have you had any further training in this field?
Yes, I like to stay up to date. I attend an annual 8-hour course. I also read the current literature, and I have to get recertified with the board every 4 years.
Now, did you apply the principles and methods that you learned in the training that you've just described to your investigation into the matters at issue in today's case?
Yes, I did.
Now, have you testified in court before?
Yes, I have testified as an expert in handwriting analysis and document examination 15 times since 2002, and that's on both sides of civil cases as well as both sides of criminal cases.
At this time, the plaintiff moves to tender Taylor Pride as an expert in handwriting analysis and forensic document examination.
Any argument or voir dire?
No, Your Honor.
Okay. Investigator Pride is accepted as such.
Investigator Pride, let's talk about why we're here today. When did you become aware of Lou Donaldson's disappearance?
Yes, in 2017, Cam Donaldson hired me to investigate Mr. Donaldson's whereabouts and to analyze an alleged last will and testament.
Let's talk about that last will and testament first. Would you recognize a picture of it if I showed it to you today?
Yes, I would.
Right, referring opposing counsel and the witness to what has been previously marked with an exhibit 14 at the bottom right-hand corner.
Okay, I've got it.
Investigator Pride, do you recognize this?
Yes, this is the purported will of Mr. Donaldson that I analyzed.
Is it in the same or substantially similar condition as to the last time you saw it?
Yes, it is.
Plaintiff moves to enter what has been previously marked as exhibit 14 and as plaintiff's 14.
Any objection?
No, Your Honor.
Okay, it's in.
Now, Investigator Pride, when was this will purportedly signed?
It says June 14th, 2012.
And was there anything suspicious about the wording of the document to you?
Yes, it says that Mr. Donaldson leaves everything to Miss Bazia should he die or disappear.
And why was that significant?
Well, I've investigated hundreds of wills over the years, and I've never seen the word disappear included in a will before.
Now, did you look into the witnesses to this will?
Yes, I did. There were 2 witnesses that signed, the defendant as well as someone named Samantha Lane.
Well, let's start with the defendant. Was there anything significant about her serving as a witness to this will?
Yes, well, it's certainly not ideal to have the person that benefits from the will to also be a witness. There's a conflict there that also provides a motive to be untruthful.
And what about that second witness, Samantha Lane? Did you look into her?
Yes, I did.
Now, do investigators such as yourself reasonably rely on testimony from witnesses of wills in investigations like these?
Yes, we always reach out to the witnesses, and if they tell us that they actually witnessed it, we take that into account. And if they tell us that they didn't actually witness it, we also take that into account.
Now, did you contact Miss Lane?
Yes, I did.
Now, did the information that you got from Miss Lane factor into your conclusions in today's case?
Yes, it did.
What did you learn from Miss Lane when you contacted her?
Objection for hearsay.
Response.
Your Honor, I believe I've laid the foundation for this information to come in under 703 as the basis of an expert opinion.
Your Honor, may I respond?
You may.
The expert witness may rely on otherwise inadmissible evidence, Your Honor. However, the expert witness cannot act as a conduit for hearsay.
Can anybody give me the standard for admissible evidence on a direct of an expert?
Federal Rule of Evidence 703, Your Honor.
No, I get that, but isn't there some sort of a balancing test I have to do?
Yes, so if the probative value substantially outweighs the risk of unfair prejudice, it would be admissible, but not for the truth of the matter asserted.
Counsel for the plaintiff, what are you talk to me about the balancing test here, because I do have concerns.
Your Honor, the information that Investigator Pride, if I may be heard at sidebar to avoid any jury conflict, the information that Investigator Pride learned from Miss Lane when she spoke to her goes directly to the validity of this will. As that is a major issue in today's case, it is incredibly probative, and the risk of prejudice against the defendant would not be unfair, nor would it substantially outweigh the probative value.
Okay. For me at this point, the balancing test is not in your favor, Ms. Maxwell. We'll see what the cross is like, but at this point, the objection is sustained.
Now, Investigator Pride, after speaking to the witnesses in this case, what were your conclusions?
I believed at the time that this will had been forged.
Now, did you also analyze the signature on this will?
Yes, I did.
And how did you go about conducting that analysis?
Yes, so first when analyzing a signature, you want to obtain known copies. So I obtained 2 known samples of Mr. Donaldson, and I analyzed those and then go to compare them to the signature in question.
Now, when you analyzed those samples, what did that analysis yield?
Yes, so the 2 known samples I concluded were in fact written by Mr. Donaldson. However, I concluded after the analysis that Mr. Donaldson did not write the signature that was on the will.
How did you conclude that?
Yes, so looking at the 2 known signatures, the writer rarely lifts the pen when writing. However, the person that signed the will did lift the pen quite a bit. There is also some differences in the letters themselves. For Donaldson, that O-N at the end of the name in the known signatures, it's what we call a lazy letter because you can't really see it. However, in the signature on the will, there's a very clear O written there. One of the other big differences was that the known signatures are written out very smoothly, whereas the signature on the will, it's very shaky. The letters it looks like it was written with a lot more force, and that signifies that it's been forged.
Now, I'd like to talk to you about the rest of your investigation for the plaintiff. Was there anything else that you discovered that factored into your conclusions?
Yes, there were also some allegations from the defendant that Mr. Donaldson had run off to Costa Rica, so I looked into those claims.
And what did you find?
I found absolutely no trace of Mr. Donaldson in Costa Rica, and I actually looked at his financial records.
Hearsay. Your Honor, may we go sidebar?
Yeah, you may. Response to the hearsay objection.
Oh, I'm sorry. Your Honor, I don't know that any hearsay has been elicited at this point.
Right, so counsel for the defense, I'm not sure that there's a statement yet, but I'll listen to argument. What I heard was that there was no evidence of him in Costa Rica so far. That's what I've heard so far.
Yes, Your Honor. Ms. Pride obtained that information by sending one of her employees to Costa Rica. She didn't personally go to Costa Rica herself. She learned that information through out-of-court statements. Therefore, it is inadmissible under Federal Rule of Evidence 802 as hearsay.
Okay. Counsel for the plaintiff, what's your response to that?
Your Honor, I would just say that she does have personal knowledge that there was no evidence. She didn't get into any specifics about what this employee of hers found specifically, where this employee checked, any of the details of that statement, simply that she is not aware of there being any evidence in Costa Rica that he was found there.
I think that's right at this point. No evidence is different than saying evidence of him there. So necessarily see a statement at this point, so the objection's overruled.
Now, I'm sorry, Investigator Pride, I'll ask that question again. Did you find anything in that investigation that was pertinent?
Yeah, so there was no evidence of him being in Costa Rica. And I also looked at Mr. Donaldson's financial records and found that no money had been taken out of his account since he disappeared.
And would you recognize a copy of that financial record if I showed it to you today?
Yes, I would.
Referring opposing counsel and the witness to what has been previously marked as Exhibit 15. And Investigator Pride, if you'll let me know when you have that up.
Yes, I've got it.
Investigator Pride, do you recognize this?
Yes, I do.
How do you recognize it?
This is one of the financial records that I investigated.
Is it in the same or substantially similar condition as to when you last saw it?
Yes, it is.
Plaintiff moves what has been previously marked as Exhibit 15 into evidence as Plaintiff's 15.
Any objection?
No, Your Honor.
Okay, it's in.
Now, Investigator Pride, how did this record factor into your investigation?
Yes, well, as I had just mentioned, there was no activity in this account after Mr. Donaldson disappears, and there's almost $100,000 still in the account. So if he were to try to disappear, he would have had to do it without taking any money out of this account.
Speculation.
Yeah, okay, I'll sustain it
And I
as
also
to the latter portion of the answer.
move to strike that statement, Your Honor.
Sure.
Investigator Pride, I'll ask that question again. Without getting into the conclusions that you drew, could you tell us what facts about this record were pertinent in your investigation?
Yes, the main thing that appeared suspicious to me was that the amount of money, almost $100,000, and that it had not been touched since Mr. Donaldson disappeared.
Now, Investigator Pride, were there any of Mr. Donaldson's personal belongings found in Statesville?
Yes, his car was found at an airstrip with his glasses and keys inside.
And why was this significant?
Well, because I learned in my investigation that he had very bad eyesight and would not be able to fly one of his planes without his glasses.
Now, were there any other documents that you became aware of during the course of your investigation without getting into specific contents of them?
Yes, I became aware that Mr. Donaldson had attempted to get a temporary restraining order against the defendant.
And when was that filed?
I believe that was filed on just 2 days before the signing of the will.
And how did that factor into your investigation of the will's validity?
Yes, it seems very odd to me that you would take out or attempt to get a restraining order and then 2 days write a will, leaving everything you own to that person.
Thank you, Investigator Pride. No further questions at this time.
Okay, Cross.
Ms. Pride, you're a forensic document examiner, right?
That's correct.
And in doing so, you have to collect samples.
Yes,
Now, you would agree that the best samples are originals, correct?
yes, that's true.
Not copies.
Correct.
Now, in this case, you collected the signature from the temporary restraining order,
That's correct.
the signature from the driver's license,
Correct.
and a signature from a note, correct?
Correct.
But a majority of those signatures were in fact copies, were they not?
Yes, unfortunately, that is what I had to work with.
Now, right, that's what you had to work with, but you also had a note written by Mr. Donaldson, did you not?
Yes, I did.
An original note
Correct.
and not a copy.
Correct.
Now, you would agree with me that someone's signature can change for multiple reasons.
Yes, there's always slight variations in signatures.
Right, like age,
Yes, that can be factored in.
The type of pen used,
Right.
or the simple fact that someone just wanted to write their signature differently.
I suppose so.
Now, you've analyzed hundreds of wills before.
Correct.
You've seen the language on these wills.
I have.
Now, people don't have to use the exact same language every time, do they?
No, everyone gets to add their personal touches to a will, but there is certain language that is standard.
Right. And in adding their personal touch, they can consider the risks that they take in life.
Sure.
So you would agree that someone who has a riskier life may just use different language.
Yes, that is possible, though I have never seen that before.
Now, Ms. Pride, you would agree that flying a plane alone is risky, right?
Objection calls for improper opinion.
Response.
Your Honor, it's common knowledge that flying a small plane alone is in fact risky behavior.
Yeah, I tend to agree overruled.
Ms. Pride, you would agree that flying a small plane is risky.
I suppose it could be, although I don't have personal knowledge of that.
And flying a small plane alone overseas is risky.
Like I said, I don't have much personal knowledge, but I could tend to agree.
Now, flying a small plane alone overseas without logging your flight plan is even riskier, is it not, Ms. Pride?
Objection, Your Honor, again to improper opinion, specifically to flight plans or any other specific things that pilots would do.
Sustained.
Let's move on, Ms. Pride. People could distribute their assets in any way that they like.
Yes.
They don't have to leave anything to their family if they don't want to.
Nope, they do not.
And here in Statesville, a beneficiary of a will could also be a witness to a will, right?
Yes, although it's not preferred, it is not illegal.
Right. Now, you also mentioned the temporary restraining order, right?
Correct.
But that temporary restraining order was denied by a court of law.
That is my understanding, yes.
No further questions. Thank you, Ms. Pride.
Okay, any redirect?
No, Your Honor, may this witness be excused?
You may. And Investigator Pride, you're welcome to stick around. Certainly if the appellate court wants you to, but you don't have to for me on a Saturday morning.
Thank you.
Okay. All right. Anything further from the plaintiff?
The plaintiff rests its case, Your Honor.
Okay. Tell you what, why don't we take a 5-minute break just to give everybody a break from the screen for a moment. I am showing folks are probably in different time zones. So it's like 11:38 where I am. Let's start back up at whatever hour you were at, 43.
Also, Your Honor, sorry.
Yeah.
I know that it takes the timekeepers just a little bit of time to calculate
Sure.
where we're at. And so could I request that we get a time check when we come back?
Absolutely will. Yeah. Great. Welcome back, everybody. Is there anything anyone has before we begin with the defense case?
Yes, Your Honor. The defense has a motion to hear outside the presence of the jury at this time.
Okay, great.
Pursuant to Federal Rule of Procedure 50A, the defense moves for a directed verdict. Your Honor, after viewing the plaintiff's evidence in the light most favorable to the non-moving party, the plaintiff, no reasonable jury could render a verdict for the plaintiff. The plaintiff has not presented any evidence that Karen Basia either intentionally or recklessly caused the death of Lou Donaldson through direct or circumstantial evidence.
Okay, I like the conciseness. Response.
Yes, Your Honor. Viewing this motion in the light most favorable to the non-moving party, which in this case is the plaintiff, in fact, given evidence of that second element that she caused it in the form of Mr. Bob Exotic's testimony today, and because we have proved that, a reasonable jury could potentially find for the plaintiff due to preponderance of the evidence.
Fair, I think that's right, given Bob Exotic's testimony. Okay, the motion is denied, and defense, you can call your first witness.
The defense calls Karen Basia, the defendant.
Oh, I'm so sorry. Yes, thank you. There's a time check there in the chat, and I had promised that for everybody. So do you see that there before we go further? I want to make sure everybody has it. Defense, do you have that too? It's there in the chat? Yes? Okay, great. Thank you so much, Taylor Pride, for that. And I'm sorry, counsel, your witness, you're calling?
Yes, Your Honor. Defense calls Karen Basia, the defendant.
Okay. Okay. Karen Basia, you've been sworn. Counsel, you can begin.
Good morning. Please introduce yourself to the jury.
Hello, all you cool cats and kittens. My name is Karen Basia.
Where do you live?
I live right here in Pioneer County.
How long have you lived here?
I've lived here for a number of years. It's where I lived with Lou.
And what do you do for work?
I am the owner of Wild Wildlife, the big cat sanctuary.
What is Wild Wildlife?
Wild Wildlife is where we protect and care for big cats like tigers, lions, and leopards. I've dedicated my entire life to this work.
Why do you do this kind of work?
Well, it's very rewarding for me. We take in animals from around the country to protect them from the bad sanctuaries out there like Icy Spots.
What is Icy Spots?
That's the business that was owned by Exotic Bob. He was treating the animal.
Relevance.
Response.
Yes, Your Honor. This goes towards the bias of Exotic Bob, a witness who we heard a video testimony from today.
How?
Exotic Bob, may we go sidebar?
Sure.
Exotic Bob owned Icy Spots. This is like 3 to 4 brief questions on how Karen Basia knows Exotic Bob, how they got involved, and to show his bias against her because she had his animal sanctuary shut down.
Okay. Overruled.
Ms. Basia, what is Icy Spots?
That's the business that was owned by Exotic Bob, where he was treating the animals so poorly.
And what was your relationship like with Exotic Bob?
We didn't have one. I tried to stay far away from him because he's crazy and says horrible things about me.
And is this the same Exotic Bob that we heard from during this trial?
Yes, it is.
And have you had issues with him in the past?
Yes, I'm the reason that he's in jail because of the lawsuit that I had against him, put him in there.
What lawsuit?
Well, my husband and I rescued the kittens from him and had Icy Spots shut down.
Now, I want to move away from Exotic Bob. You mentioned your husband. Who is your husband?
I used to be married to Lou Donaldson.
How did you meet?
We met a long time ago. Lou was so charming and really swept me off my feet, which is exactly what I needed at that point in my life.
Tell us more about that.
I just wasn't in a good place, and Lou came in and changed my life.
How did he change your life?
Well, when I met Lou and we started going steady, he introduced me to Wild Wildlife, which changed my whole world, and I found my true calling.
Tell us more about your marriage to Lou.
I loved Lou with all of my heart, but it was not an easy relationship. His family really complicated things for us because they never really accepted me.
Who never really accepted you?
It was mainly Lou's daughter, Cam.
And when you say Cam, you're referring to the plaintiff, Cam Donaldson?
Yes.
And what was your relationship like with Miss Donaldson?
Cam has never really liked me.
Do you know why Miss Donaldson didn't like you?
Yes, it goes back to when I first met Lou. I had no idea that he had a family because he kept them a secret from me. So when I finally got to meet everyone, they looked at me like I was tearing their family apart.
And how has your relationship with Miss Donaldson been since Lou's disappearance?
It's stayed the same. She doesn't like me now, and she didn't like me before.
Now let's go back to your marriage. You said it wasn't an easy relationship. Why is that?
Well, it was hard because Lou was a very secretive, private, and just really quiet man. He would just do whatever he wanted. He would fly out of the country in a moment's notice, and he wouldn't tell me about it.
And how would he leave the country?
He would fly on one of his planes. I couldn't tell you exactly how many planes Lou had because he bought and sold planes all of the time and never properly registered all of them.
And where would he go?
He would fly around, but usually he would go to Costa Rica.
Why Costa Rica?
Well, usually he kept the reasons behind his trips private, but I found out that he had a mistress, and it was something we were working through.
Did you love your husband?
Yes, I loved Lou with all of my heart, and ever since he disappeared, I found myself just waiting for him to come home.
Now, earlier we heard Miss Donaldson testify that you were at Wild Wildlife on the morning of August 19th. Why were you there?
Well, I hadn't heard from Lou, and I was getting worried, so I went to Wild Wildlife to get the lockbox.
And why would you do that?
Well, I wanted to get the lockbox because it had his will in it, and I didn't trust Cam, so I wanted to make sure to protect it. I was just doing what Lou would want.
And how do you know what Lou would want?
I was his soulmate. I knew Lou better than anyone else, so I knew exactly what he wanted, even if his family didn't want to believe it.
Thank you, Ms. Basia. No further questions, Your Honor.
Okay, Russ.
Yes, Your Honor. Now, Ms. Basia, you reported your husband missing on August 18th,
Yes, I did.
and you also visited Wild Wildlife on Sunday morning, August 19th, as you just testified.
Yes.
And at that point, you were acknowledging that he was missing.
Yes, he was, and I hadn't heard from him.
I'm sorry, Ms. Basia, you broke up. Can you repeat that answer for me?
Yes, I said yes, and I hadn't heard from him.
Now, you testified on direct that the reason you went to Wild Wildlife was to collect his lockbox.
Yes, I wanted to make sure to protect it because it had his will in it, so just in case anything happened.
Well, Ms. Basia, you gave a deposition in this case about a year ago from today.
Yes, I did.
I would like to go ahead and refer Ms. Basia as well as opposing counsel to that deposition. Now, Ms. Basia, in this deposition, you mentioned that you went to the office the night your husband went missing,
Yes.
and that Miss Donaldson tried to paint that night as something insidious.
Yes.
Counsel, do you have like a page and line for us so that we can
Yes,
be
Your
able to-
Honor. I don't have a specific page of the packet, but it is page 2 of her deposition.
Okay. Do you have a line number or like somewhere in the page?
I am referring specifically to the question near the end. It's the longer paragraph. The question is, as you have alluded to before, and then that paragraph.
Thank you.
Now, in that deposition, again, you said that Pam has tried to paint that night as something insidious.
Yes.
And you testified on direct that you specifically went there to get the lockbox.
Yes.
Nowhere in this deposition did you include that you went there to get that lockbox.
No, but I was never asked that question.
Well, you heard Miss Donaldson say that that's why you went to get the lockbox.
Yes.
Okay. Now, Miss Donaldson, you stated that Mr. Donaldson would take off at a moment's notice.
Yes, he would leave the country all of the time, and he would never tell me about it.
And he owned several planes.
Very many planes, yes.
And it's your testimony today that he flew off to see his mistress in Costa Rica.
I don't know what happened to my husband.
Will you allege that he had a mistress in Costa Rica?
He did have a mistress in Costa Rica, yes.
Well, you don't have any proof of that mistress, Miss Basia.
No, but Lou told me, and we were working through it in our marriage.
Right. Well, you don't have any phone calls or letters that were exchanged between the two of them.
I don't have any knowledge to that.
You don't know her name or where she lives?
No, I didn't want to know the name of her, would you?
Well, I'll ask the questions here today, Ms. Basia. You're the only person testifying as to the existence of that mistress.
Was there a question? Sorry.
Yes, Ms. Vicia, you are the only person testifying here today as to the existence of that mistress.
Yes.
And that was because that was simply what your husband told you?
Yes, it was something that we were working through in our marriage.
Now, Ms. Vicia, Costa Rica is pretty far away.
Yes.
And any time that Mr. Donaldson would fly off, he was pretty secretive about it.
Yes.
It's pretty normal not to hear from him until he would return to town.
It was different every single time.
Now, Ms. Vicia, you said that when you came into Lou's business, it changed your whole world.
Yes, he introduced me to my love for those big cats, and I'm so grateful for that.
Well, you also came from a pretty humble beginning. You did not have much money when you met Mr. Donaldson on the streets that night.
No, sadly, I did not.
And as you stand today, you've inherited $10 million.
Yes, all of which I plan to put towards wildlife to protect and care for those animals.
But that's a yes, you did in fact inherit $10 million.
Objection asked and answered.
Overruled.
That is in fact a yes, you did inherit $10 million.
Yes.
And that is a result of Mr. Donaldson's will.
Yes, it is.
He created that will on June 14th of 2012.
Yes, that's when he signed it.
And although you say that you were trying to work things out, your marriage was not that great at that time.
Yes, like I said, he had a mistress, so we were fighting and things were rocky.
Well, Ms. Vicia, they were more than rocky. Mr. Donaldson took out a restraining order against you just 2 days prior to signing that will.
Yes, he did, but the court denied that restraining order.
Well, regardless of whether it was denied or approved, Ms. Vicia, the fact is Mr. Donaldson did file for a restraining order.
Yes, he did.
And 2 days later, he allegedly created a will that left you everything.
Yes,
Objection
he did.
argumentative.
This is crossover rule.
I'll repeat my question, Ms. Vicia. 2 days after that restraining order was filed, he created a will that left you everything he owned.
Yes, that's what he wanted.
Okay. Now, Ms. Vicia, I'd like to talk about the evening that your husband disappeared. You claim that you went to the grocery store,
I did go to the grocery store.
and that was at 3 a.m.
Around then, yes.
Okay. You don't have a receipt from that evening today.
I don't have any knowledge to that.
Well, Ms. Vicia, let's break that down for just a moment. You claim that you went to the grocery store to buy milk for your tiger babies.
Yes, I did, but I don't keep all of the receipts that I purchase milk for.
Well, Ms. Vicia, that's a business expense, is it not?
Yes.
So although you claim that you worked for Wild Wildlife and you were such a vital role, you weren't caring enough to keep business expense receipts?
I wasn't caring enough to keep a business receipt for a $2 milk purchase.
$2 worth of milk would have been enough to sustain those tiger babies?
Probably. I don't remember the exact price. I'm giving you a guesstimation.
Okay, Ms. Vicia, but the fact is that you're alleging that when your husband went missing, you were at the grocery store. That is your alibi. So having that receipt today would be proof of that alibi.
It would be, but I don't have that.
Okay. Now, you say that that night that your husband went missing and you went to the grocery store, your car then broke down.
Yes, it did.
You didn't have your phone with you,
No.
so you just happened to flag down a random passerby.
Yes, so I could call my brother so he could come pick me up.
Right, and we'll get to that in just a moment, but you flagged someone down at 3 a.m. in the morning,
Yes.
and you did in fact call your brother
Yes.
because he was working that evening.
Yes, because he was a sheriff, so I knew he would be around.
Okay, we'll come back to that in just a moment, Ms. Vicia, but first I want to talk about this meat grinder that you had at Wild Wildlife. You'd agree you have a pretty large meat grinder on site.
Yes, it's very large and we have to use it to make sure that we feed the animals.
And you'd recognize that meat grinder if I showed it to you today.
Yes, I would.
Okay, Ms. Vicia, I'm going to refer you to what was previously marked as Exhibit 11, referring opposing counsel to the same. If you'll just let me know when you have that up in front of you.
I have it.
Okay, now you recognize this.
Yes, I do.
You recognize that as a photo of the meat grinder on site at Wild Wildlife.
Yes, it is.
And that's a fair and accurate representation of that meat grinder.
Yes.
Your Honor, permission to enter into evidence Exhibit 11.
Any objection?
No, Your Honor.
Okay, then.
Okay, Ms. Basile, if you'll just let me know that you have that meat grinder there in front of you.
Yes, I do. The picture.
You said that you need this meat grinder in order to grind up the food for your exotic cats.
Yes.
This meat grinder is big enough to dispose of a body.
I wouldn't say that. I've never disposed of a body through a meat grinder, so I don't know if that would work.
Well, I'm not asking if you did in fact dispose of a body, but you dispose of large animals to feed your tigers in this.
Yes.
So it's possible that a human body could go through this meat grinder.
Objection, speculation.
Response.
Your Honor, the witness has already stated this in her deposition before.
That doesn't mean it's not speculation. Can you speak to whether it's speculation?
Sure, Your Honor. She knows that this is large enough to grind up cows or whatever she's testified she could feed her tigers with. So I'm simply asking her, a human body smaller than a cow, so it can go through this meat grinder.
Yeah, it sounds like it's a proper, I suppose, lay witness opinion because it's rationally based on her perception and her experience with the meat grinder. The objection's overruled.
Now, Ms. Basile, you've personally used this meat grinder to feed your tigers before.
Yes.
And you have, in fact, grinded up large parts of animals.
Yes.
So it is possible that a human body smaller than those animals could potentially fit through this.
I guess, but I would never do that.
Well, regardless of whether or not you do it, I'm just asking what's possible here. If you did do that, it would take 2 people to do it.
It usually takes 2 people to work the meat grinder, yes.
And you just testified that you called your brother to pick you up that evening?
Yes, because he was working as a sheriff, so he dropped me off at home and he went back to work.
Right, well, he took you back to home or the site of wild wildlife. They're similar.
I'm sorry, you broke up. Can you say that again? Sorry.
Sure,
My
Mrs.
internet.
No problem. Your brother picked you up and he brought you back to the site of wild wildlife where your home is as well.
Yes.
And your brother is employed by the sheriff's office.
Yes.
That is the same sheriff's office that investigated your husband's disappearance.
Yes, I believe so.
No further questions, Your Honor.
Okay, any redirect?
Yes, Your Honor. Ms. Basile, were you ever a suspect in the police's investigation?
No, I was not.
Did you kill your husband?
No, I would never kill a living creature, especially the love of my life.
Did you put your husband through a meat grinder?
No, even to think of that possibility just breaks my heart. I would never want to do that to him.
Did you have any involvement whatsoever in the disappearance of Lou Donaldson, your husband?
No, I wish he would walk through that door right now.
No further questions. Thank you, Ms. Basile.
Okay, I assume there's no recross based on that?
No, Your Honor.
All right, the witness is excused. Thank you so much.
Thank you.
Anything further from the defense?
Yes, Your Honor. The defense calls Chris Renard.
Okay. Chris Renard, you've been sworn, and counsel, you can begin whenever you're ready.
Ms. Renard, would you mind unmuting yourself, please? Thank you. Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Chris Renard.
Ms. Renard, what do you do for a living?
I am an insurance claim investigator and forensic document examiner with Summit Life Insurance Company.
How long have you been with the company?
20 years.
Have you always been a claims investigator there?
No. Previous in my career, I worked for the Statesville Bureau of Investigation Crime Lab.
What did you do at the crime lab?
I was a forensic document examiner.
Now, during your time at the insurance company, were you always a claims investigator?
I was, yes, I've always been a claim investigator and a forensic document examiner.
What are your responsibilities as a claims investigator?
As a claims investigator, I am looking to see whether the company I should work for should pay out on a claim.
What do you typically look for when doing that?
I am looking to see who is staking the claim and the surrounding circumstances of that claim. Sometimes that requires going into an investigation for my company if there are disputes as to whether that claim should be paid out or not.
What do you look for during that type of investigation?
That could be anything to do with, well, that's where forensic document examination would come in. So that would be evaluating the authenticity of different documents, as well as if there's any fabrication, as well as handwriting and signature identification.
Do you conduct investigative interviews?
I do.
Do you look at police reports?
I do.
Now, how exactly did you become a forensic document examiner?
In order to become a forensic document examiner, I was certified by the Board of Forensic Document Examiners and the Association of Certified Fraud Specialists.
What was the process like in getting certified?
In order to get certified, you have to go through a bunch of different steps. It involves examination, submitting your credentials and references, things of that nature.
Now, Ms. Renard, did you apply sufficient facts or data to this case?
I did.
Did you reasonably rely on reliable methods and principles?
I did.
And did you apply those methods and principles to the facts of this case?
Yes.
Did you reach a conclusion in this case?
I did.
Do you believe that that conclusion will aid the jury today?
It would.
Your Honor, defense moves to tender Ms. Renard as an expert in the field of forensic document examination as well as claims investigation.
The objection or voir dire?
Yes, Your Honor, not to the forensic document examination, but I would like to voir dire the witness on the claims investigation.
Okay, go ahead.
Ms. Renard, you have a bachelor's in criminology, correct?
I do.
But you have no further formal education and investigation of any kind.
Well, I went to the police academy, which isn't formal education, you'd say, but it definitely trains you for what I do in my career.
But no advanced degrees.
No, it's not required.
Now, you don't have any accreditations related to homicide investigations, do you?
No, but again, that was never my specialty. I was never focused in homicides.
Right, and that's a no though, you don't.
I'm not aware if there's a particular certification that you can obtain in order to become a homicide investigator. Normally, that's just something you would specialize after the police academy, and that would be between you and your department about what unit you'd be assigned to. So I'm not aware of any specific certification you would obtain in order to be able to do that.
So that's a no then.
There is no certification, so no.
Now, you don't have any accreditations in claims investigation specifically, do you?
There's no certification to obtain in claims investigation. What is involved in claims investigation is forensic document examination, as I said, which there are certifications to obtain in that, which I have.
Absolutely. Sorry. Absolutely, I understand. Not at all in reference to your knowledge of forensic document examination. You have no other accreditations, though.
My accreditations exist from the two different associations I already said, the Board of Forensic Document Examiners and the Association of Certified Fraud Specialists.
So, again, my question was, other than those certifications, you hold none, right?
Beyond those two, I don't have any others, no.
You don't hold any licenses in the field of claims investigation either.
There's no licenses to my knowledge that you can obtain.
Mr. Nard, I appreciate the background information, but if you could, instead of telling me what licenses may or may not exist, if you'll just tell me whether or not you have them.
Well, it's important to me whether they exist, as that's the basis of my career.
Okay, Mr. Nard, so you've never been published in this area though.
I don't know what I would be published on, but no, I've never written any books, no.
No, you've never been qualified to testify in court in any areas other than forensic document examination and handwriting analysis, right?
I've testified as an expert for 25 times, and 24 of those times was on behalf of Summit Life Insurance, which involves paying out claims and insurance investigation.
But you were only tendered to testify as an expert in handwriting analysis and forensic document examination. Isn't that correct?
That's what the specific tender was, if I remember correctly. Again, that was 24 times. I don't remember the specifics of what I was qualified every time as.
But you've never testified in court qualified as an expert in claims investigation, have you?
I'm not sure.
At this time, the plaintiff would object to this witness being qualified as an expert in claims investigation.
Your Honor, may I respond?
You may.
I've established that Ms. Renard has 20 years of experience as a claims investigator, that as a claims investigator, she essentially has to, and working for a life insurance policy, she has to determine whether or not the owner to that policy is in fact dead. And in doing so, she'll look at investigative reports, police reports, and for that reason, she is an expert in the field of claims investigation, Your Honor.
This is a close call for me. Plaintiff, anything else?
I would just state that none of the things that opposing counsel has just mentioned go to the Daubert factors and whether or not this expert can be qualified under those standards.
Yeah, I'm going to limit her expertise to forensic document examination.
Understood. Ms. Renard, well, Your Honor, at this time, the defense seeks to tender Ms. Renard as an expert in the field of forensic document examination.
Yes, she's accepted as such. Yep.
Let's talk about why you're here today. How exactly did you become involved in this case?
I was asked to conduct an investigation by the company I work for, Summit Life Insurance, on whether we should pay out Lou Donaldson's life insurance policy.
And what were the reasons for looking into the payout?
My CEO asked me to conduct an investigation because there was various allegations of misconduct.
What allegations?
Well, the first allegation was that Ms. Basia, the beneficiary on the life insurance policy, was being accused of killing her husband, Lou Donaldson. And the second allegation was that Ms. Basia forged Mr. Donaldson's will.
Ms. Renard, let's talk about those allegations. When was Mr. Donaldson last seen alive?
August 17th of 2012.
When was he declared legally dead?
That would have been August 18th of 2019.
And when did the company receive the claim on the policy?
August 18th of 2019.
Now, who filed that claim?
That claim was filed by Ms. Basia, the beneficiary of the life insurance policy.
Is it common for the company to receive a claim on the life insurance policy the same day that someone is declared legally dead?
I wouldn't say it's particularly common, but we do see it in cases where people have waited years in order to receive the payout.
Ms. Renard, let's focus on your investigation into Lou Donaldson's disappearance. What exactly did you look at?
I looked specifically at Mr. Donaldson's bank account and financial records. I conducted interviews with his friends and family, and I also spoke to the police.
And how did all of that play a role in your investigation?
Well, my determination was that there was no misconduct on behalf of Ms. Basia.
Now let's talk about, well, before we get there, if the company did in fact find any misconduct, would it have paid out the policy?
No, of course not. We're not in the business of giving free money. We're an insurance company.
Now let's talk about your investigation into the alleged forgery. What exactly did you investigate?
So when I was looking into the alleged forgery, I was looking at the will itself, the language present on the will, as well as the signatures on the will. I also spoke to the witnesses who had signed and attested to the will. And then I collected sample signatures of Lou Donaldson's to compare to the one that was on the will.
Your Honor, permission to republish Exhibit 14, Plaintiff's 14?
Which one was that? Just for frame of reference.
It was the will, Your Honor.
Okay, you may.
Ms. Renard, what exactly are we looking at here?
We're looking at Mr. Donaldson's last will and testament.
And what are the components of this will? Feel free to annotate on the screen if you feel comfortable doing so.
Of course. At the top here is where we're going to see the language of the will. So this is the contents. Below that, we see the signature of Lou Donaldson on the will. Below that, we see two witnesses and their signatures. We see Samantha Lane, and then below that, we see Ms. Baja.
Ms. Renard, how many wills have you reviewed in the past?
Countless.
What's the purpose of having a witness on a will?
The purpose of having a witness is to confirm that the deceased person did in fact sign that document.
Were you able to do that here?
I was.
How?
I spoke to both Samantha Lane and Karen.
Now, you also looked at the language of the will. How did that play a role in your investigation?
Well, when looking at the language, there was one specific line that stood out to me, which was, if I ever die or disappear. That language was suspicious to me as I had never seen it before. However, it does seem like Mr. Donaldson did disappear given he hasn't been seen for 5 years.
Now let's talk about Mr. Donaldson's signatures. What process do you use generally to investigate forgeries?
I use a 3-step process.
What's step number 1?
So my first step is to gather known samples of the person's handwriting.
What type of samples do you typically look for?
I look for anything original in that original that I can collect of that person's handwriting. So whatever I have access to is what I go with.
And what's step number 2?
So the second step is to analyze those samples for the individual characteristics in that person's writing.
What type of characteristics do you look for?
So I'm looking at the overall signature, but also the individual characters. So what I'm looking for are things like the way the person capitalizes the letters, the legibility of their writing, the way that they embellish their letters, things of that nature.
Now what's step number 3?
The third step is to compare those known samples and the characteristics that I've identified to the alleged forged signature.
Would looking at those signatures help you testify today?
It would.
Now, what sample signatures did you in fact collect before we get there?
Sure, I collected a signature from Mr. Donaldson's government-issued driver's license, as well as a signature on life insurance paperwork that he had filled out for my company.
Your Honor, Ms. Renard, please take a look at Exhibit 007 in your trial packet and let me know when you get there.
Okay.
Do you recognize it?
I do.
How do you recognize it?
I've seen it before.
What is it?
This is my signature analysis.
And is it a fair and accurate representation of your signature analysis?
It is.
Your Honor, defense moves what has been previously marked as Exhibit 007 into evidence as Defendant's Exhibit A.
And let's just keep all the pre-markings so we can keep them straight if we can. Any objection?
No objection, Your Honor.
It's in.
Also, Your Honor, I know that we have agreed to constructively redact in this jurisdiction. I would like to invoke that now with the signature chart, as there is a portion that I would not like to be published to the jury.
I will.
Which part do you want to constructively redact?
There is a notes section in that signature chart report. An expert report is never admissible in a trial, Your Honor. It is work product privilege.
Okay, response from the plaintiff.
Yes, Your Honor. Pursuant to the rule of completeness, I believe that if they are fine with bypassing that rule about expert reports coming in to show these signatures, then we should also see the notes that are written underneath it.
Well, so tell me why the jury needs to see that for the appropriate context for the things that are coming in. It's not just like, hey, I want it. The rule of completeness is more than that. It's different than that.
Yes, Your Honor. If I may be heard outside the presence of the jury.
Sure.
This exhibit at the bottom of the page where the notes section is specifically says that this witness was inconclusive in her findings about these signatures, and that she cannot say whether or not it was a genuine signature. I believe that the witness will probably refer to another report that she published in this investigation where she says she does believe that this signature was genuine. And so in addition to the rule of completeness, this is also an inconsistent statement that I believe that the jury should see and that it would go to their full understanding of this expert's analysis.
Okay.
Your Honor, if I may.
Yeah, I don't need you to. So I'm going to allow you to redact. Doesn't seem like it needs to come in for the completeness of the signature card portion of this, and it's not an inconsistent statement as of yet. That may change later. We'll see what the testimony is for the remainder of the direct and then in the cross. So at this point, it can come in as constructively redacted, or if you want to do some fancy Zoom thing and actually redact it, you're welcome to. Either is fine.
Thank you, Your Honor.
You're welcome.
Ms. Renard, can you indicate what sample signatures you collected on this page?
Sure. I collected the first one at the top here. This is the signature that was present on Mr. Donaldson's life insurance paperwork. The one below that is the signature collected from Mr. Donaldson's driver's license. And then the one below that is the alleged signature on the will and testament.
Now, in analyzing the sample signatures, what did you find?
So when analyzing the sample signatures, I found that they matched, and they are indeed Lou Donaldson's signature.
What did you find in comparing the sample signatures to the signature on the will?
So when I compared the sample signatures to the signature on the will, I found that there were sufficient similarities. For example, the loops in the letters are consistent. We can look at the L and see, there's a smaller top loop and a bigger bottom loop. That was consistent, as well as present in the other letters. The loops were the same. The stroke direction was also the same. The legibility of this person's writing was consistent. The capitalization was consistent, as well as the curves in the person's writing. Obviously, there are also some differences, as no one is going to write their signature 100% the same every time. We expect differences in people's signatures. And those differences I found were inconclusive at best. So the similarities outweighed those differences. And then I also determined, in my career, we're well aware that someone's signature can change over time for multiple reasons. And given the fact that, these different signatures were at different points in time, it wouldn't be out of the realm of possibility that these differences could be attributed to that.
What factors may cause someone's signatures to change exactly?
So there are a variety of reasons. It can be age related, it can be health related. It can also be due to the fact if the person's really focusing on writing, or if they're distracted or not careful when writing, as well as the simple fact that someone may have just chosen to write their signature differently.
Ms. Renard, was your conclusion in this case based on a professional degree of reasonable certainty?
Yes.
What is your conclusion?
My conclusion is that I believe the signature on the will is close enough to Mr. Donaldson's known signature that I did not have the grounds to contest payment based on Ms. Baja's allegations. And so we went ahead and paid out the policy.
Thank you, Ms. Renard. No further questions.
Okay, cross.
Yes, Your Honor. Now, Mr. Renard, you were assigned to investigate the disappearance of Lou Donaldson, correct?
Amongst other things, yes, that was one of them.
And specifically, you were assigned to look into whether or not there was evidence that Ms. Baja killed her husband, right?
That was an allegation that we were concerned about, yes.
So that's a yes, you looked into it.
Yeah, I did.
And you'd agree that when investigating crimes in general, it's important to look into motive, right?
Of course, yeah, it would be.
And you'd agree that relationship issues can be motive in violent crimes.
It could be.
Relationship issues like divorce.
It could be.
Adultery.
It could be.
But whenever you conducted your investigation, you didn't look into any possible relationship issues between the defendant and her husband.
No, I didn't. I didn't feel the need to.
So then you weren't aware that Mr. Donaldson had tried to file a restraining order against his wife?
That wasn't something that I had knowledge of, no.
So you didn't know that this order was filed 2 days before the will was purportedly made.
That wasn't something I took into account in my evaluation.
So it didn't factor into your conclusion then.
No, to the best of my knowledge, it was denied.
But at the time, you didn't know about it, so it didn't factor into your conclusion at all. Yes?
Right at that time, it wouldn't have factored into my conclusion.
But you did look at Mr. Donaldson's financial records, right?
I did.
And you noted that he did not spend or deposit or withdraw any money after the day he disappeared.
Right, in his one known bank account.
And you don't think that it's plausible that he's alive and well somewhere given that information, do you?
I'm not sure. I'm not sure what the status is. I mean, he very well could be still alive. I can't make that determination.
But you would agree that it's just common sense that someone wouldn't leave almost $100,000 in their only bank account if they're living a life of luxury on an island somewhere.
With all respect, counselor, I can't say that. To my knowledge, Mr. Donaldson is a very wealthy man worth over $10 million. To me, it would be weird that he would only have one bank account with a little under $100,000 given how much money he has. So I couldn't say that.
Is it your testimony today that you can't say that it's common sense that he's not sitting on an island somewhere?
I can't say either way.
So you completed a report in this investigation, correct?
I did.
And you included every pertinent fact and your opinions in that report, right?
To my best, yes.
Right, I'm referring opposing counsel and the witness to the Summit Life Insurance Company report. I apologize, I don't have the electronic page number of that because I have a paper copy, but that would be the file.
Okay, just give us a second. Counsel for the defense, let me know when you have it. I
Yes,
just want to make sure you have it.
yes, and it's on page 37 of the trial packet, Your Honor.
That's helpful for me. Thank you. You said 37?
Yes.
And Mr. Renard, if you'll just let me know whenever you have that up in front of you as well.
Mm-hmm.
Now, if you don't mind, could you just read that last line of the third paragraph and let me know whenever you're done?
Yeah, I said it's just, or do you want me to read it out loud or?
If you want to, but to yourself is fine.
Okay.
Have you finished reading that, Mr. Nard? So is it still your testimony that you don't think it's common sense that he's not sitting on an island somewhere in light of his financial records?
I said it's common sense someone wouldn't leave $100,000 in their only bank account if they had been living life of luxury on an island somewhere. But again, we only have knowledge of one bank account. I didn't have access to potential other bank accounts and wasn't able to gather that information. So I would stand by my statement.
Okay, Mr. Renard. So let's talk a little bit more about your investigation of this will. You thought that the wording was suspicious, didn't you?
I did. I said that.
And you've investigated hundreds of wills over the course of your career.
I have.
You've never seen that language before.
No.
Now, you analyzed the signature on Mr. Donaldson's will as well, right?
I did.
And to do this, you got signatures, known signatures of his will.
I did.
And you conducted an analysis and your conclusion was that these signatures were close enough, right?
I concluded that the similarities outweighed any of the differences that I found.
But it was still possible somebody could have forged this signature, right?
It could be. For my determination, it's a low probability, but anything is possible. I can't say with 100% certainty, as no one can.
Let's talk about the witnesses to this will. You said that you spoke with them?
I did.
Now, one of those witnesses was the defendant, right?
Correct.
And it's not ideal to have a beneficiary of a will act as the witness to it, is it?
It's not ideal, but it happens.
That's because the beneficiary of a will would have a vested interest in whether that will was executed, correct?
They could have one, not always.
The beneficiary of a will doesn't always have a vested interest in its execution?
Sometimes people don't even know that they're beneficiaries on a will. It would depend on the individual circumstances.
Well, if they signed as a witness, you'd think they'd be aware of it, wouldn't you?
Correct, if they're a witness on the will.
So the other witness that you looked into was Samantha Lane, right?
Correct, I talked to her in person.
Right, and she told you at that time that she had seen Mr. Donaldson sign the will.
Yes, I interviewed her in person and she indicated to me that Mr. Donaldson had signed the will.
Right. So a month later, you received a letter that was purported to be from Miss Lane, right?
Yeah, allegedly.
And you'd recognize that letter if I showed it to you today.
I would.
Referring opposing counsel and the witness to what has been marked as Exhibit 8. And Mr. Nard, if you'll just let me know whenever that's in front of you.
Yep,
You recognize this letter.
I do.
You recognize it because it was sent to you about a month after you spoke to Miss Lane in person.
It ended up in my mailbox, yes.
And it is in the same or substantially similar condition as to when you last saw it.
Yes.
The plaintiff moves what has been previously marked as Exhibit 8 into evidence as Plaintiff's 8.
Any objection?
Yes, Your Honor, I'm going to object onto hearsay under Federal Rule of Evidence 802. Samantha Lane is not a witness to this in this case, Your Honor.
Response?
Your Honor, if I may be heard outside the presence of the jury.
Sure.
This letter contains information that, if proven true, would be affirmative evidence that the will was fraudulent. I intend to go into Miss Renard's authentication of this letter and her failure to follow up on it, which goes directly to the credibility of this witness and the thoroughness of her investigation.
Your Honor, may I respond?
You may, but counsel for the plaintiff, I'm not sure that responded to the hearsay objection. You gave me a lot about relevance, but this was a hearsay objection.
I'm
Do
sorry,
you
Your
have
Honor.
anything else you want to add? Yeah.
It won't be going to the truth of the matter asserted, simply to the thoroughness of this investigation and the credibility of this witness.
Got it. So it sounds like a 705 attack. Yes, go ahead, counsel for the defense.
Your Honor, Samantha Lane is not a witness to this case. Additionally, opposing counsel stated that Ms. Renard didn't confirm this letter. Ms. Renard took active steps to verify this letter by trying to reach Samantha Lane and was unable to do so. This letter is purportedly from Samantha Lane, however, that it has not been verified, Your Honor. It is hearsay under 802 and should be inadmissible. However, if you do let it in for under 705, I ask for a limiting instruction, Your Honor, and that's all.
Yep, I think it is admissible under 705. I will give a limiting instruction and caution counsel that you can't talk about it for the truth of the matter in the letter come closing argument, but for the limited purposes of examining what the investigator relied on, what they ignored, I'll allow it in. And of course, counsel for the defense, you can make any of those points in terms of that you can clean any of that up on redirect. All right, so it's admitted.
Now, Ms. Renard, this letter was purportedly sent by Miss Samantha Lane, right?
Purportedly, yes.
And it says that she did not, in fact, see Mr. Donaldson sign the will.
That's what it says.
And that, in fact, she was coerced into signing that will.
That's what it says.
That she was not honest with you whenever you last spoke.
That's what it says.
Now, if this will was authentic, if this letter was authentic, that would be affirmative evidence that the will was fraudulent, correct?
Objection, Your Honor. Opposing counsel is using this for the truth of the matter asserted.
I don't think that question does that. The objection's overruled.
I'll ask my question again, Ms. Renard. If this letter was authentic and was sent by Miss Samantha Lane, that would be affirmative evidence that the will was fraudulent, right?
That would be evidence that she didn't see Mr. Donaldson sign the will, so it could be yes.
Well, if she didn't actually see Mr. Donaldson sign the will, then her signing would be fraudulent, right?
Her signing would be fraudulent, yes.
So then the will would be fraudulent, yes?
Yes.
So whenever you received this note, you didn't initially reach out to Miss Lane, did you?
I did attempt to contact her.
But not initially. First, you reached out to the defendant, right?
Right, that was important to me.
Yes, and you reached out to her, you told her about the letter you received.
I did relay.
And then after that, at that point, you tried to reach out to Miss Lane, right?
Of course, I wanted to see what both sides of the story were and why I was receiving this letter that mysteriously came from someone that I have no address on, that I haven't been able to contact, that I had an in-person conversation with and was able to confirm she did in fact sign the will. So I was wondering why I was receiving this letter. Yes.
No, I agree. Very important to authenticate it. So you tried multiple avenues to contact her.
I did.
And as we sit here today, you have not been able to reach her.
No.
And so because of that, you decided to disregard this letter as a hoax, right?
I decided to put our in-person conversation as precedent, and my interactions with her that I had in person over this letter that had no address on it and came mysteriously to my mailbox. Yes.
Because you decided that there was no way that you could authenticate it?
At that time, there was really no way to authenticate it.
But it was in your possession, right?
It was.
And you had the will in your possession as well.
It was.
And there's a signature on this letter purportedly by Samantha Lane, right?
Reportedly, yes.
And coerced or not, there's no dispute that Miss Samantha Lane did sign the will.
Sorry, can you repeat that?
Sorry, I said that coerced or not, there is no dispute that Miss Samantha Lane signed the will herself, right?
She told me she signed the will, yes.
And you're an expert in handwriting investigation or analysis, excuse me.
I am.
It's a big part of your job.
It's part of my job, yes.
Why you're here testifying today, right?
Correct.
But you didn't try to authenticate this letter by comparing the signature on it to the one on the will.
No, that wasn't what I was hired to do.
No further questions at this time.
Redirect.
Yes, Your Honor. Ms. Renard, why is it important to speak to witnesses in person?
Well, as an investigator, you want to get a vibe off a person. You want to see what their demeanor is like, whether they're nervous, how they interact with you, what they say, how they say it. And that's important to me. And when I talked to Samantha Lane, all of that indicated that what she was telling me was the truth.
No further questions. Thank you, Ms. Renard.
I assume there's no recross based on that.
No, Your Honor.
The witness is excused with a thanks to the court. You're welcome to stay, but again, Saturday morning, you certainly don't have to unless someone else is making you do that. Okay, anything further from the defense?
Your Honor, the defense has no live witnesses, any more live witnesses to call at this point. However, we do have a transcript that we would like to read into the record.
Okay, I assume you've talked about this in advance and everybody knows which portions that the defense seeks to admit. Is that right?
Yes, Your Honor, the plaintiff is aware of every portion that we would like to read in from the Carl Bannister October 30th, 2019 deposition.
Much an improvement to my round last night. Are there any objections from the plaintiff as to any of those portions?
No objection, Your Honor, and I apologize for the interruption, but I would request a quick time check to know how far I can get into a cross-examination of this unavailable witness.
Sure, we can do that. Hey, magic time check person. Can you let us know where we stand?
Yes, I have that the plaintiffs have used 54 minutes and 24 seconds. And the defense has used right around 35 minutes.
Okay. And with that, defense, have at it.
Yes, Your Honor. Starting on page 1 of the deposition of Carl Bannister, towards the bottom, Your Honor, there are not line numbers, so I'm unable to direct you as to the exact line number, so I'll attempt to give guidance as to where it's at in the deposition. Page 1.
George, you have the page in the electronic file, anybody?
I believe it's 33.
Okay, thanks. I'll figure it out from there. Yep, thanks.
Starting up a little bit above the bottom. Okay, let me ask you about that night, early morning hours of August 18th, 2012. Do you remember the pre-dawn time?
Yes, I do.
And how do you remember it?
I was on duty that night, graveyard shift, so from 12 a.m. to 8 a.m.
What do you remember about that time?
Well, it was a normal sort of shift. I was just answering patrol calls when I got a personal call from Karen.
When was that?
It was close to 3 a.m. She had to go out to the grocery store late at night in order to get some milk or something for some newborn tiger cubs. She had car trouble and needed a ride home as soon as possible to get back to the cubs.
Did you go to pick her up?
Yes, I did.
Did you use your patrol car?
Yes, she was actually in my patrol area.
Going further down the line on page 34, a little bit above the bottom, how was she doing when you met up with her?
She was fine. She was just really concerned for those newborn cubs and wanted to get back to them as soon as possible.
Turning to page 35, starting at the examination at the bottom. Deputy Bannister, how was your relationship with Mr. Donaldson?
It was fine. He did some great things for my sister, helping her find her passion for animals, big cats in particular, but he could be difficult.
What do you mean by that?
Well, he was moody at times and suspicious of people. He seemed paranoid. He would go off to Central America for extended periods of time and not want to talk about what he was doing down there.
Were you worried about your sister and her relationship with Mr. Donaldson?
I'm always concerned for my sister. I love her because I love her. She's family, but I tried to keep out of their personal relationship as it was not any of my business.
Let me ask you about picking Miss Basia up when she had car trouble. Was that appropriate for you to do while you were on duty?
It wasn't an issue. Like I said, she broke down in my patrol area, so there was no problem. I could have done that for anyone who was stranded by the side of the road. It just happened to be my sister.
Have you ever been disciplined or received a complaint in your job?
No, not once.
Nothing further to read from this, Your Honor.
Okay, anything in rebuttal from this?
Yes, Your Honor, just briefly, if I could have my co-counsel read in our part as well.
Sure thing. I assume, again, that this has been exchanged and no objections from the defense. Is that right?
Correct.
No objections.
I'll direct your attention to the bottom of page 1. How do you remember it?
I was on duty that night, graveyard shift, so from 12 a.m. to 8 a.m.
I'd like to direct your attention to the top middle area of the second page. When did you pick her up?
Well, I was just finishing the paperwork on a DUI arrest, so it took me just a few minutes. I wrapped up what I was doing and met her around 3:20 a.m. or so.
And directing you to the top middle of the third page. Are you also aware that there is no record of your patrol vehicle moving from 3:20 a.m. until nearly 6:30 a.m. as it was showing it was near the grocery store close to Miss Baja's home during that time?
Yeah, I looked back at that in preparation for this deposition, and the records show that my transponder, the device that gives the location of the patrol car, was malfunctioning, cutting in and out. The issue was noted in a maintenance log, and it was replaced the next day.
Thank you. No further questions.
Okay, anything further from the defense?
Defense rests, Your Honor. However, at this time, we do have a motion to be heard outside the presence of the jury.
Okay. Sure, go ahead.
Pursuant to Federal Rule of Procedure 50A, the defense renews our judgment for a directed verdict. Your Honor, after viewing all of the evidence in the light most favorable to the non-moving party, the plaintiff, reasonable minds cannot differ. There has been no evidence presented that shows that Lou Donaldson is actually dead, either circumstantial or direct, and that Karen Basia either intentionally or recklessly caused Lou Donaldson's death.
Okay, counsel, response.
Your Honor, I'm going to reply that we stand on our previous argument, as well as add in that the expert today did not discredit our case prior. Oh, Your Honor, you're on mute.
I almost got through this entire trial without doing that. Okay, I'm going to deny the motion. Let's take a break before closing arguments. So I have it as like 12:45 here. So wherever you are in the world at whatever hour 55, in about 10 minutes, we'll come back to closing arguments, okay? And we'll get another time check then. Great. Okay, yeah. Should we put you on the live stream? Do you want to be on the live stream? Welcome back, everybody.
Do we have the results of that time check?
I think that's a great idea. Time check. Fabulous person, are you there?
Yes. I have that the plaintiffs have 14 minutes and 36 seconds remaining for their close, and the defense has 33 minutes and 19 seconds remaining for their close.
But you're not going to use it all, right?
No, Your Honor, but I would sorry.
No, I meant the 33 minutes. And yes, you can reserve any additional time for rebuttal.
Perfect, thank you.
I mean, you could use 33 minutes, but maybe don't. Maybe.
No,
I don't want to coach from the bench, but.
No, when we timed it, it was only going 32, so don't worry.
Oh, good. Wow, thanks. Okay, everybody ready? Yes?
Yeah, sure.
Great. Okay, we will hear from the plaintiffs.
May it please the court, counsel, members of the jury. We are here today because Lou Donaldson is not. We are here today because Cam Donaldson no longer gets to spend holidays with her father. Because she will never answer her phone to hear her father's voice asking her how her day is going. Because he won't be there to walk her down the aisle or to hold her future children. Because she will have no more Sunday family suppers. We are here because Miss Donaldson's father was ripped from her life, and her memories of him have been painted with grief and confusion. We are here today because Lou Donaldson is not. And Lou Donaldson is not here today because of the defendant. We know that the defendant killed her husband, and we've heard some evidence suggesting exactly how she did it, but the truth is, we weren't there. Now, obviously, she's not going to tell us exactly what happened to his body, where it was, or might even still be. The truth is, we don't know the details of the final moments of Mr. Donaldson's life. But after everything we've heard today, we know he died at the hands of the defendant. And we know that the defendant didn't stop there. Instead, she proceeded to steal and destroy his last will and testament, oust his daughter from the family business, and then forge and coerce her way into getting everything Lou Donaldson owned. Soon, you'll receive a verdict form, and with that verdict form, you will have the power to put an end to the 8 years of suffering that Miss Donaldson has endured, knowing that her father's murderer was in control of his final legacy, and there was nothing she could do to stop it. But for you to be able to exercise that power and serve that justice today, there are a few things that we needed to prove to you by a preponderance of the evidence. Now, the judge will come and talk to you soon, and she'll explain exactly what that means, but it's not complicated. If something has been proven by a preponderance of the evidence, that simply means that you believe it is more likely than not that it occurred. So when you're weighing the evidence that you've heard today, I want you to imagine a set of scales. And if you think that there is even a feather more on the plaintiff side of that scale today, it is your duty to find the defendant liable. But after everything that we've heard today, the weight of the evidence against the defendant feels more like a 2-ton tiger than a feather. Now, the first thing that we had to show you today was that it is more likely than not that Mr. Donaldson is deceased. Now, there is no dispute that nobody has seen or heard from Mr. Donaldson since August 17th, 2012. But the defense has suggested that we don't actually know that he's dead. He could be sitting on a beach somewhere right now, sipping a pina colada with his illicit mistress. But members of the jury, his only pair of glasses and his keys were found right here in Statesville. And you saw his bank account. Not a dime was withdrawn or deposited since the day he disappeared. Now, other than the fact that there is absolutely no evidence that Mr. Donaldson did flee to Costa Rica, other than the defendant's claim, it also just doesn't make a lot of sense because Mr. Donaldson was a grown man. If he wanted to leave his wife and go be with a mistress in Costa Rica, he didn't have to do it in secret. There was absolutely no reason he would have needed to leave the business that he built, all of the wealth he had earned, and cut off all contact from his only child. When he left his first wife to be with the defendant, he didn't stage a disappearance or fake his own death to do it. He just did it. Now, there's no reason to believe that he would have done it this time. Now, that brings us to the second thing that we needed to prove to you today by a preponderance of the evidence, that Mr. Donaldson's death was caused by the intentional or reckless conduct of the defendant. And members of the jury, bear with me because over the course of this trial, we have learned a lot about why and how the defendant killed her husband. Because we know that Mr. Donaldson was last seen on August 17th, 2012, around 6 p.m. We know that less than 24 hours later, he had been declared missing. Now, you heard Ms. Donaldson tell you that at this point in time, nobody was alleging that Mr. Donaldson was missing other than the defendant. And this is the same woman who told you today on the stand that her husband traveled often. She didn't always know where he was. He didn't always tell her where he was going. So why, if it was normal for her not to know where her husband was, why would she have reported him so quickly? And if it was just out of this intense concern for her husband, it didn't seem to be affecting her too terribly much when she walked into work on Monday and fired his daughter. Don't you think that if Miss Baja thought that there was even a chance that her husband was coming back, she would have waited maybe a few days before firing his daughter? We know why none of this adds up. We know why it all happened so quickly. We know why she wasn't holding her breath for her husband to come back. She already knew he was dead. She knew he was dead because she killed him herself. And this murder wasn't out of nowhere. Because you heard how 2 months before Mr. Donaldson went missing, he tried to file a restraining order against the defendant. So we know that this will isn't valid because that restraining order was dated 2 days before this alleged will and testament was put into or was allegedly signed. We know that it doesn't make any sense that Mr. Donaldson would have gone from wanting to legally distance the defendant from him to instead deciding to disinherit his daughter, the mother of his child, and decide not to create a foundation for his sanctuary so that he instead could get everything he owned to the defendant. Now, that restraining order isn't the only evidence we heard today that suggests a pattern of threats and violence. Because you also heard the video from Exotic Bob. And he told you that the defendant had threatened to feed him to her cats just like she did her husband. Now, Exotic Bob is an eccentric character to be sure, but you heard the defendant tell you that it would be possible for the meat grinder on her property to dispose of a human body. Now, she told you that it makes a terrible mess, but members of the jury, she had an entire sanctuary full of cats to choose a feline cleaning crew to help her clean this mess up. And she told you it took 2 people to operate it, but members of the jury, she told you that that night, she had somebody with her. Her brother, Carl Bannister, who picked her up and took her back to the very site where this meat grinder was located. Now, you also heard the testimony from Deputy Bannister that his location device on his car that evening conveniently malfunctioned. Now, pay attention because it didn't malfunction the entire night, and it didn't even malfunction for his entire shift from 12 to 8. It malfunctioned from 3:20 a.m. to 6:30 a.m. And you heard him tell you that he met with Ms. Baja at precisely 3:20 a.m. So we know that she had the ability to do this. And we know all 10 million reasons why she did it. After he was dead, she took over the business. And after she waited the 5 years legally required and had him declared dead, she executed his will and got everything he owned, about $5 million, all said and told, and also got a life insurance payout for $5 million as well. That brings us to the next element, that Ms. Donaldson suffered injuries because of her father's death. Now, Ms. Donaldson told you how much she loved and respected her father. She looked up to him her whole life, and when she was old enough, joined him as his right-hand girl at the business as well. Now, Ms. Donaldson lost her job. She lost her inheritance. She lost her peace of mind at the hands of the defendant, but nothing can trump the loss of her father. And while no amount of money can make up for the loss of that father, there's no question that the $5 million that the defendant gained when she cashed in that life insurance after his murder should be returned to Donaldson's daughter. And there is no question that the $5 million that the defendant inherited from that fraudulent will that we all saw today should be returned to Ms. Donaldson as well. But the defendant stole a lot more than her father's estate from Ms. Donaldson. And the damages for those emotional and tangible injuries should be considered separately from the economic damages. Now, the judge will talk to you soon about assigning monetary value to these intangible injuries because it can be a difficult thing to wrap your head around. There's no dollar amount that can be placed on the relationship between a father and a daughter. There's no dollar amount that can erase the years of suffering that Ms. Donaldson has endured without answers or any meaningful consequences befalling the murderer of her father. There's no amount of money that can make up for those lost phone calls, the life advice he would have given her, or the memories that they would have made together. But I submit that those emotional damages are worth at least as much as the $10 million economic injuries that Ms. Donaldson suffered at the defendant's hands and should be awarded to her in addition to that $10 million. Now, the last thing that we had to prove to you today, the last element, it's simple and it won't take a lot of time to address. The last question we needed to answer was whether or not Ms. Donaldson's injuries were due to the defendant's conduct. Without the defendant murdering her father, Ms. Baja would still have her dad. Without the defendant ousting her from her father's business, to which she had put in 20 years of her life and passion, she wouldn't have lost her income and her last remaining connection to her father. And without the defendant's robbery and destruction of Mr. Donaldson's original will and replacement of it with the laughable forgery that we saw today, Ms. Donaldson wouldn't have lost her legacy. So when we trace back the source of every single emotional and economic injury suffered by Ms. Donaldson, we find only one source: the defendant. At the end of the day, when you look at each element, the weight against the defendant clearly outweighs that feather needed to find her liable. And members of the jury, nothing will make up for the years of suffering that Ms. Donaldson endured. But today, you have as much power as anybody on this earth ever will to right some of those wrongs. Because today, when you receive this verdict form, you will have the power to put an end to that 8 years of suffering. You will have the power to hold the defendant accountable for the things that she has done. Because today, when you receive that verdict form, you will have the power to find her liable.
Okay, thank you. Defense.
Lou Donaldson was a risk taker, and Karen, his victim. Lou Donaldson and Karen meet when she's at a low point in her life. She's young, alone, doesn't have much to her name, until one night, this charming and intelligent man offers her a ride. Lou Donaldson. And the rest is history. The two fall madly in love with each other, and Lou takes Karen under his wing, showing her the world of exotic animals, lions, leopards, tigers. Eventually, Lou Donaldson's passions for these animals become Karen's. And the two of them dedicate their time and their energy into building wild wildlife together. Now, as the years go by, Karen starts to lose Lou, piece by piece. You see, Lou is a millionaire. And with that, he feels like he could do whatever he wants. If he wants another lioness, he'll get one. If he wants another tigress, he'll get one. If he wants another woman, he'll get one. And that's exactly what he did to Karen. Karen fell in love with a millionaire playboy. Now, these affairs, they take a toll on their marriage, but Karen loves Lou, and she wants to make it work. And in Lou fashion, the two of them keep the affairs private. Karen keeps working and working and working for her relationship, but Lou, without a care in the world, continues to fly out to Costa Rica to see his mistress. Lou's living life on the edge. No one knows how many planes he has because he doesn't register them. No one knows where he flies out of. No one knows when he flies out because he hardly tells anyone. Until one day, Lou Donaldson doesn't come back. That's when things come crumbling down for Karen and the plaintiff. Karen waits 5 years. 5 years of no calls, no signs, nothing. But she has to keep wild wildlife running for the large cats, for Lou. And the only way to do that is through the proceeds of his life insurance policy. So Karen declares Lou legally dead. Now the plaintiff wants answers. The plaintiff is seeking someone to blame. The plaintiff is blaming Karen Basia for her dad's own choices. Members of the jury, the answers don't lie within this trial. That's the story that brings us here today. Today, the plaintiff had a burden to prove this case by the preponderance of the evidence. And to do that, they had to prove 4 elements, not 1, not 2, not 3, but 4, members of the jury. And it's your responsibility and yours alone to assure that they meet their burden, to hold them to that burden. Today, the plaintiff didn't meet their burden. That burden is still hovering over them as I sit here and speak. And let me tell you why. The plaintiff had to prove that Lou Donaldson is dead. Members of the jury, we don't know whether Lou Donaldson is dead. All we know is that a private man that would up and leave at any given moment left one bank account untouched and glasses in a van. We don't know whether Lou Donaldson had another bank account in Costa Rica the same way he had another woman. We don't know if Lou Donaldson had any cash on him. All we know is that Lou Donaldson wouldn't register his flight plans, and the plaintiff admits that. All we know is that Taylor Pride, the private investigator, sent one person to find one person in a country filled with millions of people. Of course, Taylor Pride's not going to find Lou Donaldson, but that doesn't mean that Lou Donaldson is dead. And that doesn't mean that Karen killed him. Today, the plaintiff had to prove that Lou Donaldson's alleged death was caused by Karen's intentional or reckless conduct. Members of the jury, the plaintiff hasn't shown any intentional or reckless conduct, 0. Karen came onto this trial and talked about the early morning of August 18th, 2012, and how she had to go to the grocery store to get milk for baby cubs. And on her way back, her car breaks down. So she calls her brother, Carl, a law enforcement officer who has never been in trouble at his job. She doesn't call her best friend the love of her life because Lou Donaldson would up and leave at any given moment without telling her. Lou Donaldson is not reliable, but Carl is. And Carl will get her to those baby cubs quick, which is exactly what she needed. Now, the plaintiff argued that Carl Bannister's tracker was conveniently malfunctioning. Members of the jury, what evidence has the plaintiff shown that it wasn't malfunctioning? The plaintiff didn't show a maintenance report from the police department indicating that the tracker was working just fine. Nothing. The plaintiff hasn't shown any intentional or reckless conduct by Karen. Now, the plaintiff also had to show that Cam Donaldson has suffered injuries as a result of her father's death because of the actions of Karen, because of the intentional or reckless conduct by Karen. Members of the jury, Chris Renard analyzed the signature on the will. Chris Renard said that the signature on the will appeared to be Lou Donaldson's and that there's multiple reasons why someone's signature could change. Age, health, the type of pen used, the fact that someone just wanted to write their signature differently. Members of the jury, it's possible that Lou Donaldson didn't wear his glasses when he signed that signature. It's possible that his pen was heavy and that's why he lifted it off the pen. It's possible that Lou Donaldson just wanted to write his signature differently. Now, the plaintiff wants you to believe that the language on the will alone was suspicious, that the word disappear raises this red flag. Members of the jury, Lou Donaldson was a risk taker. Flying a small plane alone is risky. Flying a small plane alone overseas is risky. Flying a small plane alone without logging your flight plan is even riskier, members of the jury. If his plane goes down, the airport wouldn't know where to find him because that flight plan would indicate Lou Donaldson's route. So if that plane goes down, Lou Donaldson would have disappeared. The language on the will is Lou Donaldson's and Lou Donaldson's alone, members of the jury, because Lou Donaldson knew that by the risk that he was taking, it was possible that he could disappear. Now, Lou knew that Karen was so dedicated to wild life. And that's why Karen was the sole beneficiary of his will and his life insurance policy. And after gaining control of wild life, Karen made a decision that she had the full authority to make, to fire Cam Donaldson. A decision that she had the full authority to make, a business call, members of the jury. Now, there's no denying that what happened here is sad and it is confusing. But we have to put those feelings aside for just a moment. Because our justice system was not put in place to give someone millions of dollars because daddy didn't want to put him as a beneficiary under their will. Our justice system was not put in place to give someone millions of dollars because their dad decided to leave and never come back. Members of the jury, today you'll receive a verdict form. And this verdict form is the plaintiff's verdict form, and you'll see that it asks you to assess damages. But to answer this very simple verdict form, you have to determine 4 things are true. You have to determine that the plaintiff met each and every single element of their case. Members of the jury, the plaintiff failed to meet their burden. They failed to meet their burden because they can't prove whether Lou Donaldson is dead. They can't tell us. They failed to meet their burden because they haven't shown any intentional or reckless conduct. Members of the jury, they can't meet their burden because they haven't shown what injuries Cam has suffered based solely on Karen's intentional or reckless conduct. So we ask you, members of the jury, to come to the right conclusion here, that Karen Basia is not to blame. Lou Donaldson was the risk taker. And now Karen is dealing with all of his consequences. Thank you.
Okay, thank you. Can I get a time check for the rebuttal?
Yes, there is 1 minute and 6 seconds left for rebuttal.
Okay, there you go. Whenever you're ready.
Thank you, Your Honor. If I die or disappear, members of the jury, we don't need an expert to tell us that Mr. Donaldson didn't write that in his will. Nobody writes that in the last will and testament, except maybe somebody who is forging the will of somebody that they are about to make die or disappear. Mr. Donaldson isn't on a beach in Costa Rica. He didn't die some other way. He was murdered by the same woman he tried to get a restraining order against not 2 months before he went missing. Same woman who claimed he was missing less than 24 hours after he was last seen. The same woman who has threatened to feed people to tigers, just like she did her husband. The same woman who forged and coerced her way into getting everything after he was dead. The only fatal risk that Mr. Donaldson took was when he picked up a mysterious hitchhiker and brought the defendant into his life. Find her liable.
Okay, thank you very much, everybody. This concludes our trial today. So we don't do feedback here, lucky you. But I do want to take just a quick moment to thank everybody. This was great. It's a well-tried case. So thanks to the coaches who are here. Thank you so much to the witnesses and the jurors who gave their time to do this. We literally could not do this without you. And anytime anybody gives their time on a Saturday morning to an endeavor like that, we're really, truly very grateful. And to you, the advocates who have put in so much time and effort, just thank you. It was fun to watch. And if any of you are 2Ls, I know that an early tournament like this for a 2L is really just hard because you're still learning evidence. And I think you guys did great on the evidence stuff. Everybody's going to continue to learn and progress with that. But like, if it's your first tournament, if it's this early, it's I don't know, sometimes a little scary. You guys acquitted yourselves really well. And you should be proud and your coaches should be proud. With that, I'm going to wish you luck towards advancing in the future rounds. I'll say go get some food. I hope you make the break. And just again, thank you to everybody. Be well. Take care.
Thank you.
Bye.
It's a pleasure meeting you guys.
You as well. Thanks, guys. Good luck.
Bye, you too.